Mic check, 1, 2, mic check. What's that? Mic check, 1, 2, 3, 4. Mic check, 1, 2, 3, 4.
9 o'clock. Can caller number 1 identify themselves? It is *6 to unmute.
This is Neil Matthews. Can you hear me?
Yes, we can. Thank you. Okay, are all of the parties present? I can go through and check real quick, and then we'll enter appearances. CATXI, OPC, Clean Grid Alliance. Well, just go ahead and go. Hello and good morning. Today is October 27th, and the current time is 9:01 a.m. The Commission has set this time for an evidentiary hearing in the case captioned as "In the Matter of the Application of Ameren Transmission Company of Illinois for Certificate of Convenience and Necessity under Section 393.170.1 Revised Statutes of Missouri relating to transmission investments in Northwest and Northeast Missouri." That is case number EA 2024-0302. My name is Riley Fuel, and I'm the regulatory law judge presiding over this hearing. Will counsel for the parties enter their appearance for the record for Ameren Transmission Company of Illinois?
Good morning, Your Honor. Appearing on behalf of Ameren Transmission Company of Illinois, Carmen Fosco and Christine Prorock, with the law firm of Witt Sturdivant, LLP, 180 North LaSalle Street, Chicago, Illinois, 60602.
Thank you.
60604, sorry.
Thanks, Judge. And in-house for ATXI, we have Eric Dearmont and Jason Kumar. Our business address is 1901 Choteau Avenue, St. Louis, Missouri, 63103.
Thank you. And for Clean Grid Alliance, are they present?
Yes, we are. For Clean Grid Alliance, Judith Ann Willis and Elizabeth Wheeler. The law office of Judith Ann Willis is at 2313 Route J, Jefferson City, Missouri, 65101, and I'll let Elizabeth give her address.
Good morning, this is Elizabeth Wheeler. I am in-house counsel at CGA, and our address is 571 Asbury Street, Suite 200 in St. Paul, Minnesota.
Thank you. For MISO,
Judge, I believe MISO, they did not plan on
Sure.
attending. Yep.
yeah, I knew several parties had excused themselves, figured some based on how many were present online. For MEC,
Good morning, Judge Ewell. This is Peggy Whipple with Healy Law Offices. The address is 3010 East Battlefield, Suite A, Springfield, Missouri, 65804.
okay, thank you. For Renew Missouri, for Sierra Club,
Good morning, Judge. This is Caitlin Stiltner appearing on behalf of Sierra Club with Great Rivers Environmental Law Center, and we're at 4625 Lindo Boulevard, St. Louis, Missouri, 63108.
thank you. Mark Harding, are you present?
Yes, I'm here.
Mr. Matthews, we heard from you, and I don't know that we need your addresses. Thank you. Sorry for that. Since you are landlord interveners, you're not represented. But Mr. Matthews, again, we saw you were there. If you can just state you're still here. Is it *6 to unmute?
This is Neil Matthews,
Okay, thank you.
intervener, case number EA-2024-0302.
Thank you. And for McGinley, is it Krawczyk Farms?
Yes, Your Honor. Stephanie Bell with the law firm of Ellinger Bell. We're at 308 East High Street, Suite 300, Jefferson City, Missouri, 65101.
Okay, thank you. And for preliminary matters, I know there were a couple of motions that I have not ruled on yet. I think there was a pro hoc.
Pardon me, Judge.
Yes.
I don't. Staff has not entered their appearance yet. I don't
Oh,
believe.
I'm sorry, I missed you.
Well, good morning, Your Honor.
Morning.
I'm Eric Vandergriff, joined by Travis Pringle, here to represent staff of the Missouri Public Service Commission. Our information is with the court reporter.
And the Office of Public Counsel, sorry.
It's okay. The Office of Public Counsel, this is Anna Martin as well as Mark Poston, and our address is also on the record.
All right, thank you. Sorry about that. So there were a couple of motions filed earlier that I'll take, several months ago, that I'll take with the case, but there was a motion for leave to appear pro hoc filed by ATXI for, is it Ms. Prorock?
Yes, Your Honor, that's me.
Okay, and I'll be granting that. And then there was a motion for leave to file corrected surrebuttal testimony of Ms. Eubanks and a late filed schedule. Are there any objections to Ms. Eubanks' testimony in that schedule by any of the parties? Hearing none, that will be granted as well, that motion. I would ask that anyone who's appearing remotely to mute themselves when they're not speaking, and then everyone who is here in the courtroom and remote as well to silence or turn off your cell phones to minimize distractions. Mr. Harding and Mr. Matthews, you are representing yourselves. That's perfectly fine. I will assist you when and where I can. There may be questions that I can try to explain or rephrase for you, but I cannot help you present your case. Each party will begin with an opening statement, and that's an opportunity for you to give a summary to the commissioners and me of what you expect the hearing evidence to be and why that evidence will support your case. That does not mean that you will present evidence here. That will be later, but you can explain where you're coming from. To elaborate, the opening statement is not sworn testimony or considered under oath, and thus you are not subject to cross-examination where the other parties can question you about what you stated. The Commission is also not making its decision only on what is stated during opening statements. You will present your case shortly after and can present your evidence at that time. ATXI is the applicant, so it will present its evidence first. I believe was there a motion for pre-filed testimony to be admitted?
There was a motion for all the pre-filed testimony from before the granting
Okay.
of intervention for
Okay.
the landowners.
So is that withdrawn, or
I believe we still plan on entering all of that.
ultimately offering today, though?
Yes.
Okay, thank you. I have the witness list, and since the parties have filed their pre-filed testimony, we'll only be crossing witnesses today, and I believe the order of cross was also filed. When questioning a witness, you may offer documents and other items to be admitted into evidence. Counsel for the other parties may object to the admission of your documents or witness testimony. If that occurs, you'll be given the opportunity to respond to the objections. I will then make a ruling on whether the witness testimony or document will be admitted into evidence. I'm also keeping track of these, but counsel, please confirm with me when the proceeding is complete that the list that you have of admitted exhibits. Please also try to refrain from interrupting or speaking over others when they are asking questions or responding to a question, including your own questions, unless you are making an objection. During the questioning of a witness, you must ask a question and not make statements. There is also a lot of confidential information in this case, well, at least some. I think we've tailed that back. Under specific customer information that's generally considered confidential, it's going to be difficult to talk about the case. I think there were some maps that were filed that are still listed as confidential, and then the addresses of the parties especially. Each of you, as the landowner, interveners, are responsible for your information. You're the holder of it, so Mr. Harding, Mr. Matthews, and Ms. Ginley, I would like as much as possible to keep your addresses out of this, if you can say a general region or area, so we can limit as much as we can what needs to be in camera. If it becomes necessary to talk about those items, we would go in camera. Otherwise, it'd be sufficient to refer to it as the Harding address or by name, I think is sufficient. And if any of the parties believe there's any information that should be in camera, please let me know. I'm generally aware, but I'd appreciate a heads up. Otherwise, that will be deemed as a waiver of that confidentiality for those landowner interveners. And also with us, I don't think I mentioned, we have Commissioner Mitchell here in person, as well as Commissioners Coleman and Kolkmeyer online. Chair Hahn may join us at any time.
Good morning, Judge. Commissioner Kokemeyer here.
Thank you, Commissioner. And if we can begin with the opening statements, beginning with ATXI.
Good morning, if it may please the Commission and Commissioners Kokemeyer, Mitchell, and Coleman. My name is Carmen Fosco. I represent ATXI in this proceeding. This proceeding concerns ATXI's request for a certificate of convenience and necessity for Phase 1 of what's known as the Northern Missouri Grid Transformation Program, which includes 2 projects. Those projects are the Fairport-Denny, Iowa-Missouri border, or FDIM project, in Worth, Gentry, and DeKalb counties, and the Maywood Mississippi River Crossing, or MMRX project, in Marion County. The Phase 1 projects include approximately 53 miles of new transmission line across northern Missouri, as well as a new substation and upgrades to an existing substation. The FDIM project, which is the focus of today's hearing, includes the construction of approximately 44 miles of 345 kilovolt or kV transmission line in 2 segments. There's a new 345 kV substation named Denny in DeKalb County, and there's a line between that station and the existing Associated Electric Cooperative, Inc. Existing Fairport substation. And then there's a line approximately 43 miles that runs from the Denny substation north to the Iowa-Missouri border, where we'll interconnect with another continuation of the line in Iowa that will terminate at Mid-American Electric Company's existing Orient substation in Iowa. The MMRX project is not, there's really no contested issues in today's hearing, but that's a 9-mile new 345 kV line from ATXI's Maywood substation near Palmyra, Missouri, to the Mississippi River, Illinois, Missouri border. A portion of the MMR project involves coordination with Ameren, Missouri, to rebuild an existing 161 kV line in a double circuit configuration. ATXI is a transmission-only electric corporation, and public utility is defined in subsections 15 and 43 of section 386.020 of the revised statutes of Missouri. The commission may grant an electric corporation a CCN to operate after determining that the operation is necessary or convenient for the public interest. The commission has articulated criteria known as the Tartan criteria to be used when evaluating applications for a CCN. The 5 Tartan criteria are a need for the service, the applicant's qualifications to provide the service, the applicant must have financial ability to provide the service, the applicant's proposal must be economically feasible, and the service must promote the public interest. Most issues in this proceeding are uncontested. Staff issued recommendations in this proceeding and found that, subject to certain conditions, are recommended that the commission find that the requested CCN meets the Tartan criteria. Since the criteria related to need, qualifications, financial ability, and economic feasibility, and most aspects of promoting the public interest are not contested, I will not review those in detail. However, I do want to mention the review the need for the projects to put this proceeding into its proper context. The Phase 1 projects are part of the Missouri jurisdictional portion of MISO's long-range transmission planning Tranche 1 portfolio. As explained in the company's testimony in this proceeding, MISO has shown through extensive study that the LRTP Tranche 1 portfolio, including the FDIM project, will resolve forecasted thermal issues in Missouri, increase transfer levels across MISO's region, including Missouri, and improve grid reliability during extreme weather events. The Commission recently granted a CCN for Phase 2 of the Northern Missouri Grid Transformation Program in docket number EA 2025-0087, finding this same need as those projects are related. The company accepted staff's proposed conditions with certain clarifying revisions which were agreed to by staff. This was reflected in a joint status report filed on March 7 of 2025. The agreed upon revised conditions address right-of-way acquisition and micrositing, reporting requirements, and landowner communication for current and future proceedings. After staff filed this recommendation, the Office of Public Counsel filed a response to staff's recommendation, or simultaneously, ATXI replied, and it involved certain issues regarding notice to landowners in this proceeding. ATXI contested the allegations in that pleading for the most part, but acknowledged that there were some limited notice issues. There were 3 landowners who were not originally sent a notice of ATXI's application because ATXI was not aware of those parcels, which were created as a result of parcel splits. And there were 4 landowners or parcels that may not have received notice because of the inadvertent use of an old or incorrect address. ATXI's reply to OPC's motion explained that it had sent or was sending additional notices to those landowners in accordance with the Commission's rule, 20 CSR 4240 20.0456K4, which contemplates missed notices and provides for an additional notice to be issued. Affidavits were filed showing that ATXI sent those notices. On April 4, the Commission entered an order reopening intervention because of those notice issues and setting a new extended intervention date of April 18th. There were several applications to intervene filed, and there were, at the time, 4 interveners that, landowner interveners who were granted intervention, but those orders limited intervention to the issues of routing issues affecting those landowners' properties. The parties subsequently agreed that the only contested issues in this case are the routing and siting issues raised by landowner interveners that was established at a procedural conference held on June 9. With respect to the issues, the parties filed a joint issues list on October 10th, identifying 2 overarching issues concerning the intervener landowners' issues. The first issue was whether the Commission has the authority to address the alleged concern, including alleged violations of the Commission's rule requiring notice. The second issue is for alleged concerns regarding routing and siting that fall within the Commission's authority, what relief, if any, is warranted. With respect to the authority issue, ATXI will further address that in its brief, but ATXI has identified several preliminary matters where it appears that the intervener landowners have expressed concerns affecting issues that ask the Commission to act beyond its authority. To the extent that there are assertions regarding alleged damages to property, land, value, crops, contracts, and similar items, those raise issues that ATXI views as being subject to the Eminent Domain Act, which falls within the jurisdiction of the Circuit Court rather than the Commission. There are also landowner intervener concerns regarding alleged notice issues that ATXI views as not properly raised and in that they asked the Commission to act beyond its authority because those concerns and issues have already been addressed by the Commission by reopening intervention, do not allege violations of any statute, rule, or order, or exceed the scope of intervention. Finally, on the authority issue, landowners propose route modifications that affect landowners who have not received notice in this position because they involve a route which was not proposed by the company. We also feel that exceeds the Commission's authority. With respect to the substance of the case, there are alleged concerns regarding, routing and siting, and one of those issues involves one of the issues raised or the topics is public engagement and notice. ATXI witness Ms. Leah Detmers explains how the company complied with the applicable public meeting and notice requirements for the FDIM and MMRX projects, including notice of its application, and how ATXI's public outreach process went above and beyond the requirements set forth in the Commission's rule. In addition to providing multi-session county meetings or open houses, ATXI provided a website dedicated to the program as a whole, a self-paced, self-guided virtual open house, and they also provided other ways to learn about and provide feedback on the project, such as through its project hotline. ATXI provided notice of the various engagement opportunities through a variety of communication channels, including advertisements in local newspapers, direct notice to landowners within the study area, and post on the project website. ATXI also published general notice within the affected counties in multiple local newspapers and mailed letters with information regarding the Phase 1 projects to various public and the various public engagement opportunities to each affected county's clerk, other government officials, and other stakeholder groups. ATXI followed the requirements in the Commission's rule, and in instances where issues were identified, as I mentioned earlier, ATXI issued supplemental notices in compliance with the Commission's rule. With respect to the route selection study, ATXI, along with its routing expert, Mr. James Nicholas with TRC Companies, engaged in a thorough route selection process for the FDIM and MMRX projects. ATXI's route selection process was a multi-stage process that took a large study area and used relevant constraints and opportunities, criteria, and information to reduce that large study area into a series of approximate routes or corridors. It then refined those into routes, compared those routes, and selected the best route based on quantitative and qualitative review. The complete route selection process for the FDIM project occurred in stages over an extended timeline because the FDIM project was subject to MISO's competitive developer selection process. While ATXI conducted a preliminary routing study with the identification of a route for purposes of developing its proposal to MISO, ATXI did not conduct public engagement at that time, and instead waited till it found out it was selected as the developer for the project. A number of intervener landowners alleged concerns focus on the multi-stage nature of the route selection process in consideration of landowner information during the public engagement process. ATXI's position is that those concerns are misplaced and fail to recognize the extended and ongoing nature of the route selection process with a competitive project such as the FDIM project. The evidence shows that ATXI's proposed route takes into consideration several specific pieces of feedback and information gathered during the extended routing selection study process. Those factors led ATXI to determine that its proposed route, identified as DO28, DO standing for Denny Orient, was the appropriate route and was preferable to other options, including route option DO27, which ATXI had previously considered at the time of its MISO proposal. A key factor leading to the selection of DO28 was the determination that route option DO27 was subject to a specific constraint because it crossed a parcel which was part of an active USDA regulated hog farm that would present access restrictions for construction as well as ongoing maintenance and repair. Mr. Morris testified about that and explains that in order to USDA regulations and other similar facilities that have mass-produced farming operations have restrictions to prevent disease to the food, and those restrictions are a detriment to the company's ongoing operations of a line in those cases. Based on the evidence, ATXI's proposed route is fully and properly supported by the route selection study process and the study itself. There are several proposed route modifications in this case raised by the landowner interveners. ATXI has established that its proposed route is the best or most preferable based on the routing criteria and constraints that it applied. The evidence shows that while the proposed route modifications are generally constructible, they are not supported by sound routing analysis or principles, are not efficient, add significant additional cost, and/or affect new landowners who are not affected by ATXI's proposed route and did not receive notice of the application or the proposed route that goes over their property in this proceeding. There were other landowner concerns. To the extent those concerns address the commission's authority, that are within the commission's authority, they are not supported by the facts. ATXI's process for negotiating easements with landowners is designed to fully compensate landowners for all potential damage and loss of value. Similarly, the concerns related to alleged EMF harm is not supported. Based on all these factors, ATXI asked that the commission approve its CCN and approve its proposed route, although it's certainly within the commission's authority to look at the proposed route modifications that were proposed, consider the factors that were presented, and make the judgment it determines as appropriate, which we submit as to approve the company's proposed route. Thank you.
Are there any questions from the commissioners? Before we proceed, I wanted to address, first, Chair Hahn has joined us, and then secondly, I didn't mention this earlier, Mr. and Mrs. Hyatt filed a motion or a notice of dismissal of their intervention, so they are not a party, especially for the commissioners who may not have seen that. That was filed late last night. So they won't be testifying or questioning any of the parties. We can move forward then with staff's opening statement.
May it please the commission, Judge, Commissioners. I'm Eric Vandergriff, joined today by Travis Pringle on behalf of staff in this proceeding. Now I'll go ahead and state that we're dealing with the same facts as ATSI, so some of this will sound repetitive, but we're working with our perspective of the facts, so I appreciate your patience with regard to it. This case, EA 2024-0302, represents the first phase of two planned transmission line CCNs that the Ameren Transmission Company of Illinois, or ATSI, is implementing in its Northern Missouri Grid Transformation Program in coordination with the Mid-Continent Independent System Operator, or MISO, M-I-S-O. As you know, Phase 2 is in case number EA 2025-0087, which has already been approved by this commission. On March 7, 2025, staff, along with the non-landowner parties, reached an agreement on conditions to resolve this case. The Office of the Public Counsel did not join that agreement, but I believe also did not file an objection to it as well. Those conditions are attached to the corrected surrebuttal testimony of Claire Eubanks, professional engineer, pending its entrance into the record. But we're here today to discuss Phase 1. And the question is, why is Phase 1 taking so long? It is partially because of potential notice issues and partly because of routing and siting issues, primarily regarding landowners affected by Route DL28. Let's briefly discuss the potential notice issues surrounding routes DL27 and DL28. Under the Commission's rules, an applicant must notify not only the landowners of its preferred route, but also any landowners on any known alternative route that is being considered. Staff believe that since Route DL27 was prominently mentioned in ATSI's filed testimony and was raised during several local public hearings, that Route DL27 may fall within the Commission's consideration as an alternative route as well. It is important to note that ATXI is only seeking approval for Route DO 28 in its application and did not submit Route DO 27 as an alternative route itself. At this point, it's fair to say that the Commission and the parties have made very reasonable efforts to ensure that every known landowner has had an opportunity to be heard and had an opportunity to have its argument heard on record. That addresses ATXI's initial due process issues in staff's perspective, but it does not automatically resolve the routing disputes. Some landowners allege that ATXI's notice for Route DO 28 was either insufficient or too late, and perhaps their view is that ATXI should start over and consider other routes as well. Staff's position is that the landowners in this application has had an opportunity to voice their feedback on a record, and that this application should be approved with conditions. We are also not opposed to some level of modifications being reflected in the Commission's order. What remains is fundamentally a routing preference issue. Some landowners do not want the transmission line on or near their residence. It has been wisely stated by a commissioner that in utility regulation, we often deal with NIMBY positions, which stands for not in my backyard. But the challenge before the Commission is that if it moves the line to accommodate each NIMBY objection, it risks creating a note problem, which stands for not over there either. The Commission could find that by pushing the transmission line out of one person's backyard, it could put it into someone else's, which may then raise the same objections that could be heard in this proceeding. Regarding this proceedings, staff's position is that it recommends that the Commission consider the following in its decision. First, modifications that directly affect landowners who are not notified of the Certificate of Convenience and Necessity application prior to the April 18, 2025 intervention deadline should not be considered by the Commission. Secondly, while cost impacts is always a concern, ATXI estimates its total cost to construct Phase 1 projects is $120.5 million. Staff does not object to modifications or combinations of modifications that together are anticipated to be less than 1% to 2% of the total estimated costs. And finally, where feasible, routing paths along existing roads and transmission corridors and property lines are good practice as it minimizes land impact. Staff reviewed the landowner proposed reroutes. They are summarized in Schedule CME S3 in Claire Eubanks' corrected surrebuttal testimony. In Claire's summary of route proposals, you will see that many of the proposed modifications would increase costs, introduce new right-of-way impacts, or require issuing new notice to additional landowners. If, hypothetically, the Commission were to decide to significantly change from the application's filed route, then it would only be fair to give any newly affected landowners similar notice and an opportunity to be heard as the current interveners have had. Additionally, safety concerns were raised regarding routing and siting issues. If you have questions regarding safety, please direct those questions to Mr. Sean Lange. In conclusion, staff has two expert witnesses present to assist the Commission during this hearing, Ms. Claire Eubanks, a professional engineer, and Mr. Sean Lange, also a professional engineer, both from our engineering analysis department. Ms. Eubanks can speak on the routing and siting analysis. For example, she explained how the various routes were evaluated and provided a summary of impacts in her Schedule CME S3. which is attached to her corrected sewer rebuttal, and Mr. Lange can address in his testimony regarding safety-related questions. Staff did not take a direct position regarding the landowner's concerns. However, we will state that the Commission has the authority to address any violations by the Ameren Transmission Company, Illinois, of applicable Commission orders, rules, regulations, or statutes under the Commission's jurisdiction. Staff does not recommend any further relief at this time and believes that the conditions agreed to between staff and ATSI in its joint status report filed on March 7, 2025, remedies any alleged deficiencies in ATSI's approach to this CCN case. However, if the Commission were to order one of the alternative routes proposed by the landowners in this case, staff recommends that the Commission consider 3 factors outlined in Staff Witness Claire Eubanks in her confidential sewer rebuttal testimony, and please remember to pay particular attention to Claire's filed summary of route proposals contained in Schedule CME S3. I have copies of that available today. We're here to provide any objective analysis and to answer any questions the commissions may have. Thank you.
Thank you, Council. Are there any questions from the Commission? Hearing none. If the Office of the Public Counsel would like to give their opening statement.
Hello, good morning, and may it please the Commission. So prior to today's hearing, the evidence, today's evidence presented, the Office of the Public Counsel requests that you all consider 3 facts. Fact number 1, ATXI's placement of the FDIM transmission line will affect current and future Missouri landowners who have lived here for decades or even generations. Fact number 2, Missouri law and regulation authorizes the Public Service Commission to deny a utility CCN application, grant that application as written, or grant that application with conditions. Fact number 3, the Public Service Commission's authority and its willingness to wield that authority is what protects landowners from having quasi-governmental entities invade their privacy without limitation. The OPC's central request for the Commissioners is that you keep these 3 facts in mind for the duration of today's evidentiary hearing and thereafter. While there are or were more parties to this case, in front of you today are your staff, the utility, the OPC, and the landowners. And there are more online as well. The landowners are farmers, a judge, and business owners. They are fighting for their children. They are fighting for their legacies. They're fighting for their rights. This hearing will be different from most CCN hearings. Rather than the Tartan criteria, the focus on these issues today will be on the routing and siting of these transmission lines. This hearing regards the effect these transmission lines have on the generations of people doing most of the working and paying and living and dying in this community. This hearing regards this utility's handling of the landowners' affected interests, their questions, their concerns. This hearing regards the process the utility followed that led here, the problems that process caused, and the Commission's ability to address those problems. Section 393.07 or 170.1 of the revised statutes of Missouri requires companies seeking to build service infrastructure to obtain permission and approval from this commission for a certificate of convenience and necessity. Subsection 3 of this statute, which you shall see in the documents that I passed out, authorizes the Public Service Commission to impose such condition or conditions as it may deem reasonable and necessary. In its wisdom, the Commission has established a set of guidelines that the utility must abide by to receive the Public Service Commission approval for its requested CCNs. These guidelines, enumerated in 20 CSR 4240-20.045, were created with the assistance of any and all utilities who chose to take part in the regulation process. The Commission consciously, put these guardrails in place to balance the rights and responsibilities of the utilities with the rights and responsibilities of the public, and that includes these landowners. The Public Council asks that you listen to these landowners and thoughtfully exercise your authority now. Missouri's legislature bestowed upon this commission the duty to properly balance the interests of the general public, including landowners and investor-owned utilities. Please take the abundant resources that ATXI has into account. The utility has the money and the power on its side. The landowners have their voice and their passion. In its statement of position, the OPC stated that it does not take a position on whether it believes the Commission should impose any conditions on its approving ATXI CCN. At this point, the OPC's position, or lack thereof, still stands. Instead, Public Council is here to ask that the Commission listen to the landowners who took the time to appear here today, listen to their experience with this process, and really hear what they have to say. I would like to reiterate the 3 facts that I said at the beginning of this opening. Fact number 1, the transmission line that was presented here today affects the rights of Missourians who have worked, paid, and lived here for decades to generations. Fact number 2, the Public Service Commission may deny, grant, or grant with conditions any CCN application that a utility files in its jurisdiction. Fact number 3, the Public Service Commission represents the main guardrail in place to protect the public from quasi-governmental overreach. Thank you, and if you have any questions, I will do my best to answer them.
Are there any commission questions? Okay. I think next is Mr. Matthews. It is *6 to unmute. It's *6 to unmute if you're appearing by cell phone or phone.
Can you hear me?
We can hear you now.
Great. Thank you very much, and thank you for giving me the opportunity to speak from my heart about a matter that I added up the relatives last night. There's about 40 of us that are ancestors of people who settled this farm back in 1885. And I want to talk in my opening statement about 2 issues. One is the proposed electric transmission line and towers route that would cross my farm on Route M northwest of Denver, Missouri. And I also want to support the other land and homeowners who have similar concerns about the ATXI's routing and their stages of different routes that were proposed, and particularly the rerouting that went from DO 27 to DO 28 within about, as near as I can tell, a couple of months, sometime between April of 2024 and July 16th, 17th, when the application was filed by XTI for their certificate of convenience and necessity. The Missouri Public Service statutes that go with the commission has a duty to act and the authority to address the issues affecting the property of the Missouri landowners in Worth County. I want to also address 140 years of ownership on a family farm that represents, as I've said, about 30 living ancestors of this old Missouri farm. I would be the fifth generation. Sixth generation are already adults, and the seventh generation are coming up as teenagers. And that's the way this farm's existed. I originally had been informed about by reliable parties, renters, other contacts that I have in Worth County, that the route would be following a westerly track known as DO 27 sometime in summer, maybe early fall 2024. And I am looking at the letter that I had received on July 5th with the wording that said that your property along the route of a new transmission line. Well, I assumed that maybe something had changed, but along the route could have been 1.5 miles on either side, or it could have been the right of way of Route M that went along. It never stated that there would be an easement, that it would be actually crossing my property. I relied upon this information and set it aside, and then discovered way too late, sometime in fall, that it would be crossing my property, and that there would be a certificate of convenience and necessity that would be issued to ATXI. The records reflect that the 0727 was the route that had been originally presented at the regional meeting in Worth County, conducted by ATXI officials and other representatives. And maybe it had to do with stages, but it certainly put the emphasis there. And for people who actually attended that meeting, I think most of them would still believe today that that's what the route was. What I would want the commission to give thoughtful reflection is the responsibility that ATXI had of stating very clearly to us as landowners that there were going to be several routes considered, that DO 27 and additional routes, if necessary, would be considered. And that would have been the fair and accurate way of communication. So my concern has been all along the accuracy of the communication and the presentations were the responsibility of this company. And at the time, it took no action on correcting that problem and left many landowners uninformed in a timely manner as to the new route, DO 28, that was being submitted in July, and that's currently under discussion. I personally have not seen in any documentation a timeline of this communication changes and changes in the route that have been presented by APXI, which is their responsibility. The routes, as near as I can tell, were changed between the time a presentation was made in April and between the filing of the application in July. Apparently there was no need, ATXI felt no need to notify the newly affected landowners who were not responding, knowing full well that this lack of communication and lack of a timely notification might become an issue later on. I find it unacceptable to have this level of miscommunication, and ATXI needs to be denied a certificate of convenience and necessity as a result of this disregard for Worth County landowners concerning the communication loop that didn't get, it wasn't done correctly. The Missouri Public Service Commission has the authority to address this concern and deny or require additional issues that need to be addressed before approving a certificate of convenience and necessity. I want to talk about a landowner for just a minute in a family farm that survived financial hardships, depressions, floods, droughts, hard times, and a whole lot of resiliency on the part of a lot of family members over 140 years that has real historical significance and meaning to the family members who hold the current role and future role to not only themselves, but to their ancestors who have survived these challenges and hard times. They've stayed out of debt, held onto the land, and are very proud of the fact that there's probably very few companies and property owners in America who survive 140 years in doing anything in America today. I have a feeling that the ghost of ancestors past would be aghast at the proposed easement that would be granted across an area where an old log cabin was basically buried, that it would be transmission lines with the proposed noisy Corona discharge comes from 345 volt power lines and towers. Many of my relatives who live in Kansas City and other places come to this farm, walk the land that they know their ancestors walked. And I ask you as commissioners to reflect upon what this means to a family to have a transmission line cross 1,320 feet across a farm that has been planned to maintain its history and connections to the land for the future. Current plans are for a family retreat center where a proposed easement would be located. We have plans for developing ponds and walkways around this west 40 acres on this farm and maintaining a prairie grass acres for a nature center for future generations and a set-aside pollinator acreage. A few years ago, a water line that was quite expensive was brought from the east of the Missouri Highway M to the west 40 in anticipation of these projects. None of these future plans, building plans, are compatible with the 345 volt power lines and towers and the easement that will last forever on this property. I recommend the commissioners deny this and or require the development of another route, such as a DO-27 route that followed an already existing power base or power line grid, or at least at the minimum micro-siting 1,320 feet around my farm. I would be willing to work with ATXI to find an acceptable micro-siting route. I've only had one conversation with an ATXI official, actually I think it's with Contract Land Services, which the individual proposed that it would be possible to put the line on the other side of the road. At the time I asked the question, why would I want to do that, since you would then be crossing 40 acres or 70 acres. So these are the two areas that I would want the commissioners to reflect upon, is what was the communication that got us to this point today, and what effect does this have upon the family farm, an old Missouri farm that's been in this family for 140 years. That concludes my opening statements. Thank you very much.
Thank you, Mr. Matthews. Are there any commission questions? Hearing none. We can move forward with Mr. Harding in your opening statement.
Yes, good morning. I'll just start with, I want to thank the commission for making this opportunity available. I acknowledge the task that's before the commission, and I appreciate your efforts to ensure that this CCN is handled appropriately and thoroughly. I appreciate the commission allowing us late intervener landowners to participate in this process. I'm here today. My wife is with me. We represent a group of people that are outside of the mapped area, the advertised mapped area that's been referred to already. Family is impacted, and we are in the area that didn't get some of the same opportunities to go speak that other people got. So there are a group of us, and you'll see some of that in my later testimony. But it's for myself, my family, in the future, and the same things that Mr. Matthews just spoke on. This line will be here way after I'm gone. It's important to note that there was an LPH held on January 16th, I believe, to address the concerns of staff about notifications. So at this point, I agree with staff that everybody has pretty much been properly notified and alerted to this project in the area. The main issue is where to place it. There have been 2 routes proposed and discussed a lot, the comparison between the DO-27 and the DO-28 alignment. And I want to evaluate that a little bit. While each intervener has their own unique situation, we also share some common concerns. To borrow a word from one person who is not an intervener here today, but is a concerned landowner, he provided testimony at the LPH in Gentry County in December of 2024, stating, and I quote, "This is opaque," referring to the public outreach effort in this case. Another common concern is the alleged failure to follow the regulations governing CCN in the state of Missouri. Specifically, that an applicant, and I quote, shall provide notice to the impacted, as stated in the records of the county assessor's office. They're to do that not more than 60 days prior to the date the notice is sent. The reason for that is the regulation appears to be concerned about getting very accurate, very recent landowners and get all of those people properly notified. I think there was a failure here in this case. It's crucial to ensure that the current landowners be notified, and that's why the 60-day requirement is mentioned in that regulation. The county assessor's offices are familiar with how to provide this, and that should have been done from the start to eliminate a lot of problems. This same regulation clearly states that landowners impacted by any alternate route should also be notified, and ATXI, for whatever reason, chose not to do that in this case. Additionally, ATXI failed to respect the spirit and the intent of Regulation 20 CSR 4240-20.0456K3, which is the one that requires the meeting in the county anytime there are 25 or more persons impacted. Worth County qualifies for that, and I believe ATXI will claim that the April 9th meeting in Worth County meets this requirement, and we take exception to that argument. We think that it defies logic to claim that an open house meeting held on April 9th would allow people to, quote, a reasonable amount of time to pose questions or to state their concerns, end quote, as is in the regulation. How could anybody reasonably be expected to do that about a route that didn't exist at the time of the meeting? While that meeting could arguably be said to have satisfied the requirement for DO-27, but it could not possibly provide those required opportunities for the people impacted by DO-28. And that came into existence a month after that meeting. Now, I will admit that I agree with some of the previous opening statements that since then, there have been opportunities such as this, but it's a little bit different at this stage trying to impact the difference versus the people that had opportunity at the beginning of this process. As a result of the open house meetings, after the open house meetings, over a 9-mile stretch of this line was rerouted. I believe it was done in what I would call the 11th hour. That didn't take them very long to abandon DO-27 and go to a DO-28 route, and we do not think that is justified. This effort to reroute was further complicated because the company made readily available a study area map, and they posted that everywhere. It's on the web to Connect's house and property. We are outside of that study area map, and that is the only map that we had to rely on. We did rely on that map. We did an overlay with that map, as did the neighbors. The neighbors used that map to do an overlay and determined that their property was impacted, and they attended the open house meeting, which is understandable and reasonable for them to do so, but they had an opportunity that we did not have. The advertising of that map and making it so available was very deceptive. While there are some areas of this project that are more challenging than our area, the area crossing 46 Highway, which has become a fairly populated highway in recent years because of the popularity to build there for houses, there is a location And I believe that DO 27 was selected primarily by this company and the previous company, NextEra, who also worked on this route. They both used the crossing of 46 Highway at a precise location that I refer to as the DO 27 location to cross 46 Highway. At that location, in this area of 46 Highway, there is more than 1,200 feet clearance to all residences. It does go between two residences, but each of them have over 1,200 feet. And that's what I think is the most relevant point of our case. As a result of the reroute, it just so happens that the DO 28 was placed and currently is on the interactive website to be seen at a distance of, I believe, 500 and some feet, around 500 feet from my daughter's and late son-in-law's new residence and their 3 kids. There are 2 options to accomplish avoiding residences, at least to the extent of maintaining at least 1,200 feet of clearance. You could use, and I'll discuss those in future examination. The big question, I guess, and where I have an exception to what Mr. Fosco represented the ATXI's position to be, is the eligibility of the USDA hog barn land. That is a big point of, that's a big reason for the reroute. And I want to, a lot of my testimony will be, why did they just decide on April 9th, sometime after April 9th of 2024, that the USDA hog barn somehow prevents the use of the Route DO 27. It defies logic to me, and I will argue that case. I want the commission to consider whether or not the DO 27 should have ever been abandoned to begin with, and if it shouldn't have been abandoned, should it be returned to that location. I look forward to the opportunity to evaluate these and other issues that contributed to this rerouting decision. I thank you for your consideration.
Are there any commission questions for Mr. Harding? Okay, for McGinley Krawczyk Farms.
May it please the Commission. My name is Stephanie Bell, and I represent McGinley Krawczyk Farms, LLC, who I will refer to throughout today as just McGinley. This case is fundamentally about whether ATXI's proposed transmission line route appropriately balances the public interest and the very real, very significant impacts, as you've heard already today from other landowners, on occupied family residences and productive agricultural land. Rebecca McGinley, who is seated here with me today, is a lifelong Missourian, born and raised at the property depicted on the maps in front of you. She is an associate circuit judge in Gentry County and lives with her husband and 2 young daughters, ages 9 and 7, in her family home on the land where she was born. This is not an investment property. This is not vacant land. This is where her family lives, where her children are growing up, and where 3 generations of her family have made their home since 1970. ATXI's proposed route would place a massive 345 kV transmission line within approximately 400 feet of the McGinley family home, where again 2 young children sleep, play, and grow. The route would bisect 3 of the McGinley parcels, including a 218-acre agricultural parcel and a 14.9-acre field with active row crops. One of these parcels, as is in her direct testimony, is enrolled in a Conservation Reserve Program contract with the USDA that runs until September 2035, representing a long-term commitment to conservation that would be disrupted by additional structures. The Commission, as you've heard already today, I think the parties are in agreement, has the authority to address these routing concerns raised by McGinley. Section 393-173 authorizes the Commission to impose such condition or conditions as it may deem reasonable and necessary on CCN applications. I passed out a series of maps to you that are already in the testimony and which we will offer today, and they were attached. The first 2 pages were attached to McGinley's direct testimony, the last one to her surrebuttal testimony. I'll note for the record that that third map is currently marked confidential, so I'll do my best to avoid property owner names as we talk about them. As you can see from the front page, which is Schedule MS3, again attached to McGinley's direct testimony, the route impacts 3 of the McGinley parcels. While Ameren states in its testimony it attempted to follow property lines and roads, notice for all 3 of McGinley's parcels, the route does not follow property lines or roads, but bisects directly each of her parcels. Notably, Ms. McGinley has not raised routing concerns with respect to the 2 southernmost parcels, only the parcel on which her residence is located. If you flip to Schedule MS4, the black line shows Ms. McGinley's preferred route. You'll note with the red dotted line that the proposed route by Ameren sweeps extremely close to her home, notably on the parcel next to her residence, such that she wouldn't be compensated by that route going so close to her home. Now, it appears Ameren was attempting to avoid the structure on the parcel to the left, which is noted on the map as a vacant house. But yes, that house is vacant and currently uninhabitable. You can see photos of that house attached to her direct testimony at Schedule MS5. Now, again, if you flip to Schedule MS7, which was attached to her surrebuttal testimony, which is confidential, you'll see Ameren's proposed modification 2 shown by the yellow line. But the evidence will show that this modification still requires an additional structure on the McGinley residential parcel in the southwest corner, where she currently has a productive row crop field. So you'll see that purple line. So according to Ameren, it would come down on the black line, cross over the yellow line, and then continue on that purple line that you see bisects that row crop field with a structure in that row crop field. Ameren will argue that the route parallels an existing easement, and so they didn't need to follow the roads or the property boundaries because you've got this existing easement. But the important word in their testimony is that it parallels an existing easement. It will be an additional easement, an additional encumbrance. The lines will not be put on existing structures. There will be new structures, new lines, and a new easement. And while Ameren might argue this is the best practice, as a property owner, the fact that there is already a power line on your property, which you were not agreeable to, should not make you a target for all future easements. Again, Ameren is not using an existing easement, or ATXI, I think I've been saying Ameren. ATXI is not using an existing easement, but adding a new additional and another encumbrance to these parcels, her residential parcel. So for the next line, should the McGinleys expect to be a target simply because she now potentially has 2 power lines across her property? And what about the next one and the next one? This case presents 3 fundamental questions for the Commission. First, did ATXI's route selection process give adequate weight to the difference between impacting vacant land versus occupied residences? ATXI's witnesses repeatedly emphasize the value of parallel existing transmission lines as if this principle trumps all other considerations. True, an existing smaller 69 kV line already bisects the McGinley agricultural properties. The question is whether ATXI should compound that impact by adding a massive 345 kV line so close to where a young family resides when viable alternatives exist that would not impact occupied family homes. The second question for the Commission, should occupied family homes receive consideration in route selection? The McGinley home is not just a structure on a map. It houses a family with 2 young children who would be exposed to electromagnetic fields from these high voltage lines. Studies have linked EMF exposure to neurobehavioral impacts in children, increased infertility risk for women living close to these lines, and elevated childhood leukemia risk. When ATXI had the opportunity to route these lines through vacant agricultural land instead of near occupied homes, should they not be required to do so? Third, for this Commission, did ATXI engage in meaningful consultation with the affected landowners? Ms. McGinley proposed an alternate route, which you've seen by the black line on these maps, depicted in her direct testimony schedule MS4 that would address her concerns. ATXI's own witness, Sam Morris, testifies, and his testimony I suspect will be admitted today, that he contacted the representative to the west where Ms. McGinley drew that black line, and that property owner was unwilling to agree to any changes to the proposed route. And ATXI simply gave up. No further discussion, no attempt to understand or address that property owner to the west's concerns, considering there's no residents there, and no explanation for why this property owner to the west's concerns should trump Ms. McGinley's concerns. The evidence will show a pattern of inconsistency in how ATXI treats landowner concerns. Some get accommodations, others do not. Yet when it comes to Ms. McGinley's occupied family residence, an actual home with children living there right now, ATXI claims their hands are tied by routing principles and unwilling adjacent landowners. Perhaps most tellingly, ATXI witness Sam Morris testified that while ATXI continues to support its proposed route, that they would not object to commission approval of an adjustment or modification of the proposed route across Ms. McGinley's property should the commission deem appropriate. This conditional language reveals that ATXI knows their route selection is not the only reasonable option. They're simply unwilling to prioritize the property rights and landowner concerns over routing convenience. So today, what we are seeking, as we already talked about, the Commission has both the authority and the responsibility to ensure that any CCN granted in this case includes conditions that protect affected landowners. McGinley asked the Commission to do two things. First, require ATXI to accept her alternate route. That's what ATXI has called Modification 1, that places the transmission line at least 1,000 feet from her occupied residence, prioritizing family homes over agricultural land. Second, if the Commission were to adopt Modification 2, again, that's the yellow line from ATXI's testimony, to provide assurances that they will not place any additional structures on the parcel which contains both the McGinley residence and the productive agricultural land. This Commission has the power to grant or deny certificates of convenience and necessity, but with that power comes the responsibility to ensure that when public interest requires new transmission infrastructure, the burden is distributed fairly, and the most vulnerable, in this case a family with young children, are protected to the greatest extent possible. The evidence will show that a viable alternative exists that would significantly increase the distance between these high voltage lines and the McGinley family home, and we urge the Commission to require ATXI to implement such alternative. Thanks for your attention, and I can answer any questions.
I think Chair Hahn has a question.
Good morning.
Good morning.
Just one question. If the Commission were to order either Modification 1 or Modification 2, would that require notification to different landowners?
I think ATXI suggested that in their testimony, but I don't believe so. So if we're looking at the parcel exactly west, where the black line, so okay, if we go directly west from her home, you'll see the route was already, that property owner should have gotten notice. If you go directly south, where the line takes a bend, that property owner should have already had notice. And then again, the property directly to the south, those property owners had notice of the project.
Okay, thank you.
Yes.
Are there any other Commissioner questions? Okay. And Shelley, I'm sorry, I missed your last name. Are you doing all right? Okay. We can proceed with the evidentiary portion of the hearing if ATXI would like to call their first witness.
Yes, Your Honor. ATXI calls Ms. Detmers to the stand. And Your Honor, if I may ask, we have an electronic disc with all of our hearing exhibits. Would you like those at the end of the day or earlier?
I think either's fine. whatever
Okay,
you'd like to.
we'll submit them at the end of the day.
Sure. Thank you. Okay, Ms. Detmers, if you can raise your right hand. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
Yes.
All right, you may proceed. Counsel.
Ms. Detmers, will you please state your name and business employment for the record?
Leah Detmers, ATXI.
Okay. Ms. Detmers, What's your position with ATXI?
I'm currently the manager of stakeholder relations and training for Ameren Transmission Company of Illinois.
Ms. Detmers, do you have in front of you what has been marked as Exhibits 1, 2, and 3, which are your direct testimony as filed on October 3, 2025, your Schedule LDD1 filed on July 17, 2024, and your Schedule LDD2 filed on July 17, 2024?
Yes.
And do you also have in front of you your rebuttal testimony and schedules, which have been marked as exhibit numbers 4, both public and confidential, 5, public and confidential, 6, public and confidential, and 7, public and confidential, which are your rebuttal testimony filed on October 17th, and schedules LDR1, LDR2, LDR3, and LDR3 filed on August 15, 2025?
Yes.
Ms. Detmers, was your direct and rebuttal testimony and schedules prepared by you or under your direction and control?
Yes.
And do you have any corrections to those documents?
Not at this time.
Okay. And if I were to ask you the questions set forth in your testimony, your direct and rebuttal testimony, would your answers be the same?
Yes, sir.
And is the information in your direct and rebuttal testimony true and correct to the best of your knowledge, information, and belief?
To the best of my knowledge, yes.
Okay. Your Honor, ATXI would move for admission of exhibits numbered 1 through 7 as listed in exhibit list and tender Ms. Detmers for cross-examination.
Are there any objections to ATXI's exhibits 1 through 7, confidential and public? All right, hearing none, those are so admitted. And for cross, we will begin with staff.
No cross from staff, Your Honor.
Okay. And the Office of the Public Counsel.
We have no cross at this time, thank you.
Thank you. Mr. Matthews, it is *6 to unmute yourself if you're appearing by phone. Can you hear us, Mr. Matthews? It is *6 to unmute yourself if you're appearing by phone.
I have no cross.
No cross? Okay.
Right.
Mr. Harding, do you have any cross for Ms. Detmers?
Yes, I do.
Okay, you may proceed.
If I could have my wife hand out those to the parties that need them. They're the exhibits.
Thank you.
We made an attempt to enter all the exhibits on the office site prior to this hearing. Should I proceed?
Yes, you may proceed.
Ms. Detmers, the first item that I want to call your attention to is Exhibit 814. Exhibit 814 is ATXI's response to a data request from staff. That request was made in October of 2024, and the response date is November of 2024. It states in that you queried the county assessor's offices.
Mr. Harding, hold on a second. Is that in the first collection?
Yes, it is the one labeled the letter. Exhibit 814 is the one you're looking for.
814. Okay, I see the order now. It's at the top right for anyone. I was looking. It's about midway through, towards the end.
Yeah, they are not in any particular order in your folders, and I apologize for that, but it is Exhibit 814. this is the response that prompted OPC to conduct an investigation. It clearly states, you know, that they queried the county assessor's offices in multiple places there. It says in Worth County they did that, or that you did that, Ms. Demers, on May 21st and May 22nd. And then explains the process by which you did that. Said you did it by phone, by email, or in some cases obtained it in person from the county. Is that your testimony here today, that you did do what is stated in this response?
Your Honor, I guess I object to the failure to establish some foundation first, as to whether
Sure.
Ms. Detmers is familiar with this document. And I also object, I think, to the form of the question, which was a lot of what appeared to be testimony-like and not a question, Your Honor.
I'll sustain both of those objections. Mr. Harding, ask your question in a less leading way, if that makes sense, please.
Okay, let me direct your attention to Exhibit 818, which is my data request from that same folder, from that same. If you look at Exhibit 818, and this was my data request on June 27th of 2024 for context. If
Mr.
you
Harding,
look
how is this labeled? Does it say 818 on it?
It says 818, Exhibit 818 in the top right corner.
Top right corner. Oh, it's at the beginning? Okay.
If you go to the second page of that, Ms. Detmer, your response to my question at that time, you stated that you went to Worth, Missouri DevNet Wedge, a website, to gather the addresses for the July 5th notification. I was wondering if you could clarify which of those is correct and which is not correct.
Your Honor, I'm going to object to the form of the question. I'm not certain what he's asking. I don't think that's clear at all.
Okay.
It would require looking at 814 and then looking at 818 and determining, since it's two different answers on how they gathered the landowner addresses for the purposes of mailing the July 5th letter, I was wondering which of those are true, because using a website, I will argue, is not going to the Worth County Assessor's Office. And so I'm wondering, which did you do of those two? Did you go to the Worth County Assessor's Office and contact them by email or phone call? Or did you get the information, landowner information, from devnetwedge.com?
I'll overrule the objection based on his clarifying question. Ms. Detmers, if you can answer that.
Sure. Just to be clear, for Worth County in particular, our consultant staff contacted Worth County staff at the assessor's office and were specifically told in that time frame that they were to allow the use of DevNet as assessor's records. So therefore, we utilized assessor's records from DevNet to accumulate the July 5th mailing for notification.
Is there a reason why you didn't use the assessor's records? Typically, and I believe maybe ATXI did this in 2023, they request the tax roll.
That is correct. We did request the tax roll records for all of the county parcels in 2023 for all of Worth County, not just the specific areas. We asked for all of the parcel tax rolls for all of the county, in Worth County specifically.
And when you purchased when you contacted the Worth County Assessor's Office in 2024, were you trying to access the most recent landowner addresses to meet the requirements of the regulation that requires that to be done within 60 days?
Our intent was to find out what data set we could use for Worth County, and so when we contacted the assessor's office staff, they directed us towards DevNet specifically.
Do you know who you talked to at the Worth County Assessor's Office?
I personally cannot attest to that, as this was done by one of our consultants.
Do you have any record that you contacted the assessor's office?
I do not have any personal record that they contacted the assessor's staff, as I did not personally contact that staff directly and didn't receive that direction personally. It was through our consultants.
Was it by a phone call?
I believe that our staff contacted the assessor's office by a phone call.
But you have no record of that, is that correct?
I don't keep any of the phone records for any of our consultants, nor of myself typically.
When you answer the data requests on November the 20th of 2024, why didn't you say in your answer anywhere that you contacted the assessor's office and they told you to use DevNet Wedge?
Could you point me to what you're specifically speaking about in a data request or testimony?
Yes, Exhibit 814 is your response to a data request by staff, and your response states that you queried each county assessor's office multiple times. It never says anything about that the assessor's office instructed you to go to a website to get landowner addresses.
I'm going to object to the form of the question, Your Honor. He's testifying rather than asking a question.
I'm going to overrule. And while we're on this, did you wish to admit exhibit or offer exhibit 818 or 814, Mr. Harding?
Excuse me?
Did you want to admit or offer to be admitted exhibit 818 or 814?
Yes, both.
Okay, are there any objections to 818 exhibit or 814?
Yes, Your Honor. As well, turning to 818, Your Honor, we had objected to that, to the form of that data request, and those objections still stand. It's vague and ambiguous, and so we do stand on those objections. I do not object to MPSC 022.
Are there any other objections to either? I'm going to overrule on 818, and we'll admit both of those exhibits. If you can, if you have that question still at hand, Mr. Harding, you can re-ask it. I think I overruled that as well. That objection?
Yes, I wonder, when you responded on Exhibit 814, when you responded to data request 22.0, why you didn't mention DevNet Wedge at the time of that response. Your response date is 11/20, that's November 20th of 2024, whereas the response to my question occurred in June of 2025. Why didn't you mention that you were instructed to use DevNet Wedge at the time you answered the question in November of 2024, rather than say that you got them from the county assessor's office?
I believe that at that time my statement was accurate in 814 because we did utilize direction under that county assessor's office in Worth County specifically.
Mr. Harding, when you ask a question, please wait for a response before asking an additional question.
Okay.
Thank you.
Did anybody in the Worth County assessor's office at the time they told you that you could access that information from DevNet Wedge, did they inform you that the information on DevNet Wedge is not current and does not reflect the same ownership and addresses that would be seen in the assessor's office on that same date?
I can't speak to that conversation as I wasn't a party to the conversation. Again, I wasn't a party to that conversation, so I cannot answer that question.
Do you know if DevNet Wedge provides current landowner information?
I do believe it provides current landowner information.
DevNet Wedge does not provide current landowner information, and I have emails, but these need to be added to the record, and they are confidential. And I have an email from DevNet Wedge, as well as an email from the collector's office explaining that DevNet Wedge does not keep current landowner information. If I can give you an example, Your Honor, last night I went to DevNet Wedge and put in one of my parcel numbers, and it shows 2024 data. The information on DevNet Wedge is current as of last November. DevNet Wedge will update to new addresses around the 1st of November here in a few days to reflect current addresses. The assessor's office contains current addresses as of the time that they're recorded in the recorder's office. The point of me asking is that whenever you use DevNet Wedge, you're not getting current addresses, and I don't believe it meets the requirements of the regulation.
So, Your Honor, I certainly object to that as being in the nature of testimony and not a question, Your Honor. I mean, the purpose of cross-examination is to ask the witness this question and to get her answers, not to have the questioner testify.
I'll move on.
I'll overrule it because you already got it out. So,
I want to move to another subject for Ms. Detmers. And this is labeled Hog Barn in your folder.
is it marked as an exhibit?
Yes. It should have a paper clip that keeps them separated. It's identified Hog Barn, and underneath of it, the exhibits are identified as 830 and 833.
This is one of the thinner.
Yes, it is. It's labeled Hog Barn. And these are data requests that Ms. Detmers, you responded to. The Hog Barn property has been a big subject of discussion in this case, as you know. If you look at your response, you state that you have had no communication with the Hog Barn people, the managers, and so forth. Is that correct?
Yes, we maintain that we have not had any records of contact with that property owner as it relates to this project.
Have you spoken to any of the managers of those properties?
I have not spoken to any of the managers of those properties.
Where did the information come from that the Hog Barn property should be avoided? Who determined that, and how was that determined if you didn't speak to the property owner?
I think Mr. Nicholas can explain the routing and justification as to why there was an avoidance of the hog farms in this case. My general understanding of the issue is that there are constraints when operating, constructing, and maintaining a transmission line within those USDA regulated facilities.
Okay, I'll take that up with him at that time then. I just wanted to confirm that you have not had any communications with the hog barns or the managers of the hog barns?
No, sir.
Okay. Moving through your folder then, if we go to...
Mr. Harding, would you like to offer Exhibit 830?
Yes, please.
Are there any objections to Exhibit 830 being admitted?
No objections.
And 833 as well, Your Honor?
Are there any objections to 833 being admitted?
No objection, Your Honor.
Okay, so admitted. Proceed, Mr. Hardy.
The late notification in your folder contains exhibits 803 and 826. Looking at Exhibit 803, Ms. Detmers, the commission,
So I'm sorry, Your Honor, just trying to find what Mr. Harding's referring to.
Which packet is this in, Mr. Harding?
this is in Leah Detmers' late notification.
Okay.
That's how it's identified. It contains 2 exhibits. It's thin. It has 3 pages. Exhibit 803 is the first one, and then Exhibit 826 is behind that.
And those are labeled in the top right as well?
Yes, the exhibit number is in the top right.
Here you go, Travis. We found it.
So again, Exhibit 803.
Okay. May I proceed?
In Exhibit 803, this is from staff recommendations. Staff states that the commission rule requires that landowners along an alternative route would need to be notified. Do you agree with that, Ms. Detmers?
Can you specifically state what line you're referring to?
Lines 13 and 14. It would begin with the lines 11 through 14.
I agree that that's the recommendation written.
Do you agree with the regulation that requires that?
I'm going to object to the extent it calls for a legal conclusion, Your Honor.
Sustain.
Did you notify people along the DO 27 with the July 5th letter?
Not that I am aware of, no.
Is there a reason for that?
That was not, from my understanding, that was not what was filed with the PSC at the time.
Drawing your attention to Exhibit 826, the second page.
Did you wish to admit Exhibit 803?
Yes, Your Honor.
Are there any objections to 803?
Judge, staff objects to Exhibit 803 just because it is a snippet from Exhibit 100, which the parties have already agreed to enter on the record. So just for the purposes of context, we'd rather Exhibit 100 be the proper exhibit to cite to for this rather than this one-page exhibit from our already agreed to Exhibit 100.
I'll sustain that objection.
Thank you, Judge.
You may proceed, Mr. Harding.
Drawing your attention to Exhibit 826. You were asked how many parcels provided late notice, and you responded 16 parcels on the third page of Exhibit 803, or excuse me, the second page of Exhibit 826. In your experience, is that a typical number of late notifications to send?
I wouldn't say it's typical. I would say that it is all of our intent to rectify any situation of notice, and that once we become aware of any kind of notice discrepancy, that we make all attempts to notify the appropriate landowners, whether it be a request by that parcel owner due to change of record because of sale, estates, or any other further changes in address. We do make every attempt and best effort to notify when we are made aware of those discrepancies.
Are you aware of any late notifications that are a result of having used DevNet Wedge rather than going to the assessor's office for the most current landowner addresses in this case?
I believe there are some discrepancies based upon that and updated address changes.
When you send a late notice, do you think that is sufficient notice to the person about an event that's already occurred and a deadline that's already been met?
Going to object to an extent it calls for a legal conclusion, Your Honor.
Sustain.
The item labeled interactive map in your folder, it contains Exhibit 813.
Mr. Harding, would you like to admit Exhibit 826? Would you like to offer? Sorry.
Yes, Your Honor.
Are there any objections to Exhibit 826 being admitted?
Yes, Your Honor, we object to the handwritten interlineations on this document. It's not what we produced as a data request response.
I withdraw my request.
Okay.
Would it be possible, I do apologize, would it be possible to maybe admit 820, or I think it was 826 without the writings, if we can get that?
Your Honor, I object to the extent that this is Mr. Harding's cross-examination, and it's highly unusual for another party to interject into another party's cross-examination and admission.
Are there any other objections to admitting, or to offering Exhibit 826 unaltered? I'm going to overrule that second objection, Mr. Fosco, and admit 826 unaltered.
Is that something that Mr. Harding's to submit then?
Yes, Mr. Harding is responsible to submit that.
Yes, thank you. Moving to the interactive map portion of Ms. Detmer's. We have Exhibit 813. Well, 812 and 813. So in the top right corner, you should find Exhibits 812 and 813. And this has to do with the interactive maps. Some claims made, Ms. Detmer, by you regarding when interactive maps were made available on the FDIM website. And if you would, can you just state when interactive maps were made available on Ameren.com? Anytime prior to being instructed to do so by staff around December of 2024. So this would be prior to that. Let's say March 2024 through November 2024, on what dates was an interactive map depicted on Ameren.com that would show the subject route of this CCN?
And Mr. Harding, I want to remind you, please allow the witness to answer your first question before asking a follow-up.
Yes, Your Honor.
I believe the interactive map dates are found in my direct testimony.
Do you recall if the interactive map was indeed on the Ameren.com website at any time between March of 2024 and October of 2024?
Yes.
And your answer is that the interactive map was on there, on the Ameren.com website in that time frame? The answers are conflicting is the reason I'm asking.
I'm confused by the question because there is an Ameren interactive website that's found as a link on the Ameren program page. So I'm questioning if you're asking specifically about that program page because the interactive map has a link from that program page. I think that's why I'm a bit confused on the question.
I'll rephrase my question. To initiate going to the transformation grid page, do you have to initiate that by going to Ameren.com?
Yes.
For a person that wants to find an interactive map that shows where the line route is, and they go to Ameren.com and proceed through the steps to find the map at any time between March of 2024 and October of 2024, would such a person, if they knew how to navigate the system, been able to find the interactive maps under the Ameren.com website?
Certain time periods of that time period, yes.
Do you know the dates that that would have been available?
I believe the interactive map was specifically outlined of those dates in my direct testimony.
Would you refer to Exhibit 812 and 813 and see if you can determine what dates it may have been from your answers given there?
Your Honor, I'm going to object. I mean, the witness has already answered the question as to where the dates can be found. I think it's been asked and answered.
I'll sustain the objection. Mr. Harding, can you, I guess, I'm sustaining the objection.
May I rephrase?
What was asked? I'm sorry.
May I rephrase the question?
Sure.
As public outreach manager or in that line of work, are you interested in making a map available to the people that reflects where the line is prior to submitting for a CCN application?
I would state that that is not really a fair assessment, as you're stating line. So you're asking me if we propose lines on a map made available to the public. If you're asking about a line made available to the public on a public map, the answer is no. We do not put lines on any map made available to the public.
I would call it a route.
I would also say we do not propose any select route on a map made available to the public.
At the time you're asking for feedback from the people, you don't make the route available for the people to see where the route is on their property?
I would say that we take into in consideration an area of interest in a study area and propose that interest because we want to take public feedback from community members and landowners, because we are looking at varying areas of interest, not specific routes at that time, and that based upon that feedback, we take it back to the routing team and analyze those inputs from the public, and as it relates to sensitivities, opportunities, technical guidelines, and statutory requirements. I do not agree that we put any route on any of those maps made available to the public.
I agree with you. Thank you. At least I never could find them.
Objection, Your Honor.
Excuse me.
To the
Sustained.
gratuitous statement.
Let's move to the skinny line map section of Ms. Detmers.
Did you, Mr. Harding, did you wish to admit or offer, Exhibit 812 and 813?
Yes, Your Honor, and I realize they are marked up, so I will assign someone to get the cleaned version to avoid the objections.
Are there any objections to an unaltered version of 812 and 813 being filed?
No, Your Honor.
Okay. So admitted.
I would like to cover Exhibit 829, and Exhibit 829 is marked confidential. It's from the FS website, 025.0. It is specific emails from that data request. And so this is, Exhibit 829 is ATXI's response to a data request for correspondence that happened in and around the time of the open houses. If it's necessary to go off camera, then I would like to request that, or whatever the proper process is.
Well, Your Honor, I'm looking at this. I'm not certain that the document is,
I have it towards the beginning of that packet, about maybe 5 pages in.
Your Honor, I think these represent Mr. Harding's typings of the actual data request response, not the data request response itself. And I do object to using that.
And I would be happy to provide, to enter into the record, I will provide the cleaned up, non-marked up version.
It's not a question of, I mean, there's maybe the issue of interlineations added to the document, but this is not what ATXI produced, Your Honor. That was a spreadsheet, I believe. And this is something that was created apparently by Mr. Harding. I believe.
Your Honor, what I have marked up is for convenience so that you don't have to read everything. I want to speak to whether or not the people who attended the open house were commenting and discussing and dealing with an actual line location, not an imaginary line location. That's the purpose of wanting to discuss this here today. ATXI alleges that there was no route, and clearly these people are discussing a route and their concerns about that route. In this room today, Ms. McGinley can testify that there was a specific route. To say that there wasn't a specific route is not accurate. And I'm trying to prove the point that there was a route depicted at the open house in Grant City on that day, and it was not DO 28, and it was DO 27.
I'm going to sustain Mr. Fosco's objection with the caveat that late filed exhibits will be considered by the commission, pending objection. You may proceed, Mr. Harding.
With regards to proceeding with Exhibit 829, it is a confidential document on EFIS. Should I proceed here and not mention names?
That may be difficult. Brian, we may need to go in camera here if we're going to address that. Anyone appearing by WebEx who is not a party to this case will need to log off, as we are in camera. Thank you, Brian. Okay, you said Exhibit 821.
821, correct? It's labeled deceptive photo.
Your Honor, I'm going to object to these characterizations in the record.
I haven't found the exhibit yet.
Your Honor,
I guess
like-
I was speaking to Mr. Harding's statement, calling this deceptive photo. We clearly object to that. That's improper.
Sure, I'll sustain that, and would you like that stricken from the record?
I would, Your Honor. I would request that.
I'll sustain that and strike it. How is this labeled? Is this still in the skinny maps?
Yes, it's Exhibit 821.
821, is it
It's-
labeled in the
it's
top?
It's in your last page that we haven't gone through, and it has photo in the title.
Photo, title, okay.
The exhibit is a data request from me, 13A.
This is 13A. Thank you for clarifying. See, 13. I don't know that I have a page labeled 821 in my package.
Exhibit 821 up in the top right corner.
I don't know that I have that.
It's in the folder that I handed you. Do you have another one?
Do you find that, Commissioner? Yeah, I have an 820. I do not have an 821.
Do you have one that is labeled data request Harding 13A?
I only have 13. Does anyone have a copy they can share with the commission?
And Mr. Harding, is this, you said 821, is that the one that at the top is titled DR13 in ink?
No, it says Gmail, and it says data request Harding 13A. It's labeled 13A.
Okay, I think I've I found it. Is it the one immediately behind Exhibit 820?
Excuse me?
I'm gonna permission to go see Mr. Harding.
Granted.
This is where I was, is this
Why don't we take a break while you try to find that, Mr. Harding? And everyone, we can come back at 11:15. If that's all right with everyone. We'll be recessed until then. Okay, we can go back on the record. We're back on the record in case number EA 2024-0302. Mr. Harding, you had offered Exhibit 821. Were we able to find that exhibit? I think your mic's still muted.
Oh, it's off, it's labeled photos.
Labeled
in your
photos?
folder.
For
Is
the
that-
commission's clarification, Judge, I am holding up.
Okay, so it is separate to the other. Gotcha.
This is
Yep.
data request 13A, my data request, which I would like entered into the record.
Okay,
Sorry, my mic wasn't on, Your Honor. I'm going to object just to the request to enter this into the record with this witness. If he wants to ask her a question about it, we can go from there and see what the question is.
I think that's a good way to start, if you can, Mr. Harding.
Yes, for brevity, the last page is a photo. And I want to ask Ms. Detmers if she took that photo.
Is this the photo of a road and some land? Got a blue overlay? Okay,
Is it labeled page 6 of 6 on the bottom? Is that what you're asking?
Page 6 of 6 on the bottom, correct?
6 of 6. Okay. Kind of in the middle.
This is a part of the response to a data request that I'd made, I believe, to an earlier data request. Ms. Detmers, did you take the photo that's depicted on page 6 of 6 at the end of Exhibit 821?
No, I believe that's a Google Earth photo.
Did you capture that image?
I believe one of our staff did, yes.
Do you know how they captured that image?
I can't state with certainty, but it looks like it's marked imagery date 7/23 of Google.
It appears to be from Google Earth. You don't know.
It appears to say 2025 mark date Google and imagery date 7/2023.
Let me draw your attention to halfway up on the left side of that photo. If you look close, it's been zoomed out to make it appear further, in my opinion, but you can see a vehicle parked there and just the corner of a building. And I want to draw attention to that. This imagery date is July of 2023. And this is an image that I received with your name on it, on the response. And this was a part of that response, and you don't have any knowledge of the details of this image, of how it was captured?
I would say I have a general awareness of how it was captured, but not directly from my computer necessarily.
Would you speak to how it was generally captured?
Through Google Earth and through to the appropriate imagery date that it's marked.
Do you have this image in your folder
I can
at the end of what I handed you, or my wife handed you? Do you have this image?
I'm referencing the image you're holding up, sir, yes.
Okay, I want to ask you a question about that image.
Well, I mean, Your Honor, I guess I just would ask for some foundation about that image, whatever that is.
This image is date stamped 10/28/25. I took this image on that date. I went to Google Street View, and I captured this image, and I worked quite a while, and I could never capture an image that eliminated the building and the 911 sign. It appears that the person who captured that image wanted to leave a false impression of what you could see from the Highway 46 on this date.
I'm going to object, Your Honor, to that characterization. That's not a proper question. I move to strike it.
I'll sustain and sustain the motion to strike. Please rephrase your question, Mr. Harding.
The witness doesn't have any knowledge of the photo that I asked about, so any further questions are irrelevant. And I need to ask the appropriate person. Do you know who did take that photo? Capture that image. Do you know who captured that image?
Which image are you referring to, sir?
The one that's a part of Exhibit 821. This one.
Not specifically, no. I would say it was a member of our ATXI team. Because it is publicly available data on Google Earth.
Yes, it is. Exhibit 821, I would like to enter into the record in its entirety.
Its entirety, okay. Are there any objections to Exhibit 821 being admitted?
I do object, Your Honor. It's incomplete. This was a data request about other items which haven't been asked of the witness, and the image was added as stated in the response that there was a statement in the request that the image which has not been produced and offered for admission, stated that the house was there since very early 2023, and that image was produced to show that, per Google Earth, as of July 2023, which is later than very early 2023, it wasn't there. And I think without both photos coming in, it's improper, and I would object.
Your Honor, just for clarity on the record, my comment does not state that the house was there from early 2023. I stated that the 911 address sign was there and in place and easily visible from the highway in early 2023. And the reason this is relevant to me is because ATXI claims to have made a field review in 2024, which I have a Google image of 2024. The house is clearly there, clearly visible in 2024. 2023 is just to exaggerate what you could have seen easily in 2023, this place.
I guess.
By 2024, it was a full-built house, they were living in it. And 2024 is the only time frame that's relevant, because a review should have taken place in this area, which would have revealed a house that was otherwise overlooked.
I'm going to ask a clarifying question. This may be council's. I assume ATXI is thinking the same thing. Who owns the home?
Kids?
I am going to sustain the objection as it's outside of the scope of your role in this case.
Okay.
And that was, I guess, you had asked for the entirety, you objected, so it was not entered, or not admitted.
So the entirety of 821 will not be admitted?
Yes, it will not be admitted.
Exhibit 820?
Okay. And is that in the skinny map, I believe?
Yes. No. It is. It's data request 13. It says Exhibit 820 in the top right corner.
Is it in the skinny map packet?
Your Honor, I'm not sure.
And Judge, this is Travis Pringle from staff. Yes, that does appear, at least from what I have.
Okay.
The skinny line map, Exhibit 820, is the last exhibit in that packet.
Okay. Thank you, counsel.
And also, if you have Exhibit 800,
That should be in that as well, I believe. Should be the first page in my packet, I think.
drawing your attention in Exhibit 820, Ms. Detmers. In your response, to my data requests. At A, at the bottom of that page, page 4 of 6, it states that ATXI or its consultants did conduct a field review. And we're discussing the area in which the line now crosses 46 Highway, which I believe is relevant to this case. Ms. Detmers, do you know of a field review that was conducted?
I'm generally aware of a field review, but you'd have to speak to the appropriate witness for that. I believe Mr. Harding or Mr. Nicholas can address that field review specifically.
You did respond to the requests that says that ATXI's consultants did conduct a field review, but you don't know whether that's true or not?
Well, Your Honor, I'm going to object. There's a data request with joint sponsors, and the witness has explained that Mr. Nicholas has sponsored that part of the answer.
I sustained. You can ask that of Mr. Nicholas.
Okay, very good. I would like to enter Exhibit 800 into the record.
Is that 800 or 820?
I would like to enter 820, but if I need to take that up with Mr. Nicholas, that's what I will do, however I'm instructed.
I believe it's co-sponsored by both Ms. Detmers and Ms. Nicholas, so it can be offered now as well.
I would like to offer Exhibit 820 in its entirety, as well as Exhibit 800.
Are there any objections to Exhibit 820? Take them separately.
Okay. Yeah, Your Honor, if I could have 1 second to review.
Yes.
Wait, did we?
Your Honor, this Exhibit 820 is most relevant here as I review it. It identifies the 4 people who were impacted, who are outside of the advertised study area map. So it would be more appropriate to have it admitted here if you would allow it.
And Your Honor, I guess one question I have is that I believe the DR response ends at page 5 of 6. So I think what he's moving to admit is the document with the number Exhibit 820, and then the next 3 pages. I don't object, Your Honor.
You don't object to the
To those
page?
pages, if that's what he's moving to admit.
So this is the 820, 3 of 6, 4 of 6, and 5 of 6?
Correct, Your Honor.
And where it says DR 13, is that?
Yeah, I don't know what that is, Your Honor.
I'm sorry, which part are you objecting to?
Well, I don't.
He's asking for clarification, if you can, Mr. Harding, on the last page of my packet for the skinny line map says DR 13 at the top. It
Yes.
has a B and a C underneath a map,
Yes.
and then it says objection under that. Are these confidential? Do we need to go in camera again?
I don't believe this is confidential. It's only names, but I will let you determine that. We can leave off the last page. That's what Mr. Bosco is objecting to, correct?
I just don't know what it is, Your Honor. I don't know.
Then can we omit it? It's just another picture of the same thing, so I apologize.
Okay, so you'd ask to admit those through to page 5 of 6 of Exhibit 820.
I'm sorry, did you say the first 4 of 5?
Yes, the first 4 pages, I believe.
Yes. There are no objections? Yes.
No objection, Your Honor.
Judge, I do have one request. Is there are
Yes.
4 landowner names. Is there a way that we can make sure that this is confidential due to
I-
customer-facing information?
Would we like to make the entire exhibit confidential, or just that part? I see them on page 3 of 6.
Yeah, I think that we could probably, I can possibly redact it if we need, but I would just like the names to be confidential.
Sure. So we can admit that in a confidential and public version. That's 820. Okay, moving to Exhibit 800. Mr. Harding, you asked to offer that as well.
Yes.
Are there any objections to Exhibit 800 being admitted?
And I apologize, Your Honor, but which packet was 800 in?
It is in the same packet.
In the same packet?
Yes.
Oh. Well, Your Honor, he hasn't reviewed this with the witness. I think it's a part of an open house, but invitation, but not all of it, so I do object to the incomplete. He hasn't even asked the witness a question about it.
I am prepared to.
If you'd like, Mr. Harding.
Exhibit 820, my data request 13. If you go to the second page, there's a small picture on the first page of Exhibit 820, data request 13. If you go to the next page, it's a more detailed picture. And Ms. Detmers, if you would use Exhibit 800 as a reference, I would like for you to answer this question. Is the areas that are outlined in white and red ink that appear to be identifying parcels of land within the gray area on the map in that picture?
Can you rephrase the question or ask it again, sir?
Yes, in reference to Exhibit 820, the second page, there's a large diagram at the bottom of the page. Do you have that?
Yes, it says page 3 of 6.
Yes, page 3 of 6. Do you see how there are some red lines and some white lines outlining what appears to be some parcels of land with some numbers on them?
Your Honor, I would request that we establish some foundation as to whether the witness has seen this or knows what this is before we proceed with questions about it. I object to lack of foundation.
This is a picture of Google Earth with an overlay of the Exhibit 800 map that was produced.
Mr. Harding, I'm going to sustain that objection. In a brief reminder, you cannot testify when you are cross-examining a witness. If you can ask a question of her, you may do so.
I'm asking if the areas outlined in red and white ink are within the gray area on the second page of Exhibit 820.
I was just going to say, this is page 3 of 6, I believe, correct? What you're referring to?
At the bottom, it says page 3 of 6.
Okay.
And I'm asking Ms. Detmers if the areas outlined are within the gray area in that picture.
And yes, there is a portion of the red area that is outlined in the gray.
And are you talking about the very northwest corner of the red outlined portion?
Yes.
Do you see any other places that the outlined area is within the gray area?
No.
Thank you. I have no further questions, Your Honor.
And Mr. Harding, did you wish to offer Exhibit 800 at this time? I think it was referenced in that.
Yes, I would like to enter Exhibit 800.
Okay. Is there any objection to admitting Exhibit 800?
800? Your Honor, I'm still not clear that Mr. Harding asked a question about the other exhibit, page 5 of 6, but not this one, so I guess I do object on that basis. I don't think there's a
I would like to
basis
ask
to
a
admit this.
question, if I may.
You may, Mr. Harding.
Ms. Detmers, is Exhibit 800 recognizable to you?
Generally, yes, it looks like it is submitted as part of our open house notification.
Thank you.
And now you'd like to offer it.
Yes.
Does that clarify for you, Mr. Fosco, or does your objection stand?
No, I don't object, Your Honor.
Okay. So admitted. Do you have any further questions, Mr. Harding?
No, Your Honor.
Okay. I think next is McGinley Krochik Farms.
Thank you, Your Honor. Good morning, Ms. Detmers. Earlier, you testified that there were some landowners that had late notification. Do you recall that testimony?
Yes.
Okay, and they were notified in approximately July, is that correct? Was that your testimony?
Can you reference a page and cite that?
I'll move on. Do you have any evidence sitting here today that Ms. McGinley wasn't one of those late notified landowners?
I have no information to date that suggests she was. She did show up to an open house.
Thank you.
Was that all?
That's all, thank you.
Okay. Are there any commission questions for Ms. Detmers? Okay. And I did have one question. Ms. Detmers, you mentioned that the interactive map was open for periods in the months of March and October 2024. Was it inactive at any time during that period?
Yes, for clarification, we typically leave it open between, I would say, 10 to 14 days to receive comments that can be logged directly into our system to be utilized later for our routing study. And so it's common practice for us to close that window at some point to allow for information for the routing study to be analyzed. Per those PSC recommendations, I believe that we reopened that so that others can still maintain comments, and we maintain comments to this day through other methodologies such as the hotline, on our email, as well as physical address, and we make ourselves available throughout the project lifecycle.
Okay, thank you. Now, recross by, I think, staff is who we start with.
No recross, Your Honor.
Okay, and Office of Public Counsel?
No request, thank you.
Mr. Matthews, and this would be recross on the question I asked. It is *6 to unmute yourself. Can you hear us, Mr. Matthews? We cannot hear you.
Hear me now?
We can hear you now.
Would you repeat the question, please?
The question that I asked was if there were periods that the interactive map was not active. Do you have any recross of that question, that issue?
I do not.
Okay. Mr. Harding, do you have any recross of that issue?
I apologize, but I'm not clear on the question. It has a double, could you restate it?
Sure. The question that I asked was if there were any periods in which the interactive map was not active. You can ask questions about that particular issue alone.
If I understand correctly, were there periods of time that the interactive map was not active?
Yes, that was the question I asked.
And what is the answer?
The answer that she gave was that it's open for 10 to 14 days for commentary period.
And otherwise it was not available? Am I understanding correctly?
You can direct that to Ms. Detmers.
Ms. Detmers, the interactive map was made available for 10 days and not otherwise?
That's not true. It was open for approximately 10 to 14 business days, and then we reopened it per the PSC staff's recommendation, I believe, and we'll work furthermore to do that in all of our projects, to keep it open per the recommendation until a final route is approved.
And what date was it that it was opened as per their request? Approximately.
I don't know off the top of my head.
Would that be about November or December of 2024?
It could be in a time period of, I would say, Q4 of that year, yes.
Just for clarity, the interactive map was available for 10 to 14 days in the window of time between March and October of 2024. Is that accurate?
No.
Clarify, please.
You stated, from what I understand of the question, it was only open for 10 days from March to the end of 2024. That's not accurate. It was open longer than that.
Between March and October of 2024, how many days was the interactive map made available to the public?
I would state approximately 10 to 14 business days, but again, I'd like to state that we also maintain other methodology to take in consideration and input and feedback from landowners and stakeholders.
But with regards to the interactive map being available, 10 to 14 days is your testimony.
I believe that is correct.
Thank you.
Okay. Any recross from, for McGinley Farms?
No, Your Honor.
Any redirect, Mr. Fosco?
Yes, Your Honor, I have some redirect. Let's start with the most recent, Ms. Detmers. You just answered a question about when the interactive map was available.
Yes, sir.
Can you clarify what that means? Does that mean a map with the ability to comment or something else?
So the interactive map is online through our program website, where a user can go on and drop a pin and make any comment in relation to the study area, the area of consideration that they can put into our system that goes directly to our routing and study team. And then we consider those inputs as it relates to sensitivities, opportunities, technical standards, and statutory requirements.
So when you referred to the interactive map, you were referring to what you just described, a map with the ability to drop a pin and submit comments?
Yes, sir.
Do you recall you were asked some questions by Mr. Harding regarding a phone call that ATXI's consultant had with the Worth County assessor directing ATXI to the DevNet webpage to obtain records when they were requested from the assessor?
Yes.
Now, you testified, as I recall, that you were not a party to that phone call itself, correct?
That is correct.
Okay. But you were advised of the phone call and the substance from your consultant, is that correct?
Yes, sir.
And that falls within your job duties, correct?
That is accurate.
Okay. In addition to what you already testified to, are you aware of the substance of those conversations? Was there anything else besides being directed to the website that occurred to your knowledge?
Not in particular, that we could utilize that information to take information about the landowners and their parcel information.
In referring to parcel information, are you aware, was there a discussion regarding parcel numbers?
Yes, there was. There was a discussion of, I believe, what we would call PN numbers or parcel numbers versus, I think, UPN numbers, Uniform Parcel System, or I'm sorry, Universal Parcel, and the differences in those numbers.
And so those discussions with the assessor not only involve pointing ATXI to the DevNet page, but explaining how those parcels could be looked up or the numbers, the PIN numbers converted?
Yes, and that was described in my testimony.
I'm sorry, Your Honor, give me just 1 second to look at my notes here. You also had discussions, or do you recall the questions and answers with Mr. Harding about the timeliness or the timing of com records and his request to you about a full assessment role obtained by the company or its consultants in 2023?
Yes, I recall that.
Okay. Referring to the assessment role that was obtained in 2023, do you recall the dates that those were requested and obtained from the assessor?
I couldn't speak to the approximate dates, but I can say that the full tax roll of all the county parcels in 2023 were requested around February, and I believe we obtained them in March of 2023.
Okay. Your Honor, I have part of my question involves the name of the owner of one of the parcels. And I can ask the question trying not to use it, but if the witness needs to refer to it, then I think we would need to go into closed session.
Why don't we go ahead and go in camera, Brian? Anyone entered on WebEx, if you were not a party, please remove You may proceed, Mr. Fosco.
Ms. Detmers, do you recall you were asked some questions by Mr. Harding regarding the whether there were routes or transmission line routes disclosed at the open houses?
I was asked about that, but we never proposed any routes at the open houses.
And my question to you is, can you explain what the process that the company engages in and what the goal is of having an open house where I believe you testified study areas or areas of interest are disclosed rather than routes? Why does the company do that?
So in an effort to take in input from stakeholders and specifically landowners in an area of interest, we host those open houses not just because we're required to by Missouri standards, but also because we want to learn more about the project area so that we can find options and opportunities that are, least impactful, as well as taking in information that we may not know from the community. We do this in an effort so we can take in that data and perform routing study and review that in conjunction with other sensitivities, like I said, opportunities through the lens of technical guidelines from our engineering team as well as statutory requirements. We do this to gain more insight into the project area, and I think that we make every best attempt on our projects to do that and work with landowners and receive that input.
And how long have you been involved in open houses, county meetings in Missouri?
Specifically over the last 10 years.
And is that process you described typical of transmission projects in your experience?
I would say this case in particular is atypical of how we traditionally route and look at our public process, specifically because it was a competitive project. Typically in greenfield routing, we would have differences, and since this was a MISO competitive bid, there were other avenues that were, I would say, not typical of our routing and processes.
So the timing of the public engagement process was atypical because it was after an initial preliminary routing study?
Yes, typically we don't have a preliminary routing study, but since this was a MISO bid proposal, we were required to do a preliminary routing study as part of our application to MISO.
Okay. And just to clarify, the process of having a study area in open houses, is that fairly typical of how ATXI and other transmission companies, to your knowledge, conduct county meetings?
Yes, I would say that it is very typical to have a study area of notice, as well as varying areas of interest to the routing team, and that's fairly common in all of our routing of projects.
Thank you, Your Honor. No further questions.
Okay, thank you. I think we're gonna go ahead and take a recess for lunch. Is 12:30 a good time to come back? Is that good for the court reporter as well?
Yes. And Your Honor, is the witness excused or?
Yes, you may be excused, Ms. Detmers.
Thank you.
All right, so we'll be back on the record at 12:30. All right, if everyone's ready, we can go back on the record. This is case number EA 2024-0302, and I believe it is ATXI's next witness.
Thanks, Judge. This is Eric Dearmont for ATXI. At this point, we would call Mr. James Nicholas to the stand.
Mr. Nicholas, can you raise your right hand? Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
Yes.
All right, thank you. You may proceed, counsel.
Thank you. Good afternoon, Mr. Nicholas. How are you? Good. Good. Can you please state and spell your name for the record?
James Nicholas, Nicholas.
And Mr. Nicholas, by whom are you employed and in what capacity?
I'm employed by TRC Corporation, or Environmental Consulting and Engineering Company, and in that capacity I lead routing and siting efforts for energy infrastructure projects.
Mr. Nicholas, are you speaking into the microphone? I can hear you.
Does this work?
That works better.
All right.
Much better.
Thank you.
Much better.
Let me do this.
Sorry. You may proceed, counsel.
Did you get that, or should I ask again? Okay, thanks. What was your role on this project, Mr. Nicholas?
I led the route selection study for the project.
Very good. And you filed both direct and rebuttal testimony in this case, correct?
That's correct.
Okay, and specifically, your direct testimony, which has been identified as Ameren Exhibit 8, the corrected version of which was filed on 10/3/25. That's your direct testimony, correct?
Correct.
Okay. And you also filed what has been identified as Ameren Exhibit 9, representing the corrected version of your first schedule, JND1, the corrected version of which was also filed on 10/3/25, correct?
Correct.
Okay. You had one more schedule with your direct testimony. I believe it's been identified as Ameren Exhibit 10. That's schedule JND2, and that schedule was filed on July 17th of 2024, correct?
Correct.
Okay. Then you also filed a piece of rebuttal testimony. You have a confidential version, which has been identified as Ameren Exhibit 11C, and that confidential version was filed on August 15th, 2025, right?
Correct.
And then there's also a public version, which has been identified as Ameren Exhibit 11P, and that public version was filed on 10/16 of this year, correct?
I believe so.
Okay. Is all of the information contained in your testimony, both the written testimony and your exhibits, true and accurate to the best of your knowledge, information, and belief?
Yes.
Okay, and all that information was prepared by you or somebody working under you or at your direction?
Yes.
Okay. And if asked the same questions today as were contained in your direct and rebuttal testimonies, would your answers be the same?
They would.
Very good. I have no further questions and would move for the admission of Ameren Exhibits 8, 9, 10, 11C, and 11P, and tender the witness for cross.
Are there any objections to Exhibits 8, 9, 10, and 11, P and C? So admitted. I believe, staff, you were first on the list to cross.
No cross from staff, Your Honor.
Okay. And public counsel?
No cross, thank you.
Thank you. And is it Harding next?
Good morning, Mr. Nicholas.
Morning.
Sorry, I believe it's Matthews. Sorry, I want to get in order. Mr. Matthews, do you have any cross? Is star
I've
6?
been muted myself. I'm just checking to make sure you can hear me.
Yep, we can hear you now.
Thank you. Mr. Nichols, yes, I do. I do have a cross. Mr. Nichols, you indicate in your rebuttal testimony in my section, part 2, that the valid reason for the adoption of DO 28 was primarily due to the addition of the Hogue Farm property as a constraint. review for me what these detriments, burdens, and sensitivities are associated with the hog farm. It may be written someplace, and I just haven't found it, but it seems to be leading the primary reason why this got switched. Because in the DO 28 versus the DO 27, you said the DO 28 is comparable or slightly more favorable than DO 27. And if you statistically analyze the two using your numbers, I agree with you. It's only slightly more favorable, statistically speaking. But I go back to my question is, detriments, burdens, and sensitivities associated with this hog farm. Can you just state to me what those are again?
Your Honor, I would object to the form of the question, but I think even more fundamentally, it calls for speculation.
Mr. Matthews, can you rephrase your question in question form as well?
I want him to explain what sensitivities are associated with an active hog farm that changed the route from DO 27 to DO 28. What sensitivities?
Do you still have an objection, Mr. Dearmont?
It's a little irregular, but if I could pose maybe a couple clarifying questions, it may help us along.
Sure.
The identification of the hog farm as a sensitivity, Mr. Nicholas, was that your identification, or was that something that was identified by the project team?
That was identified by the project team as a major constraint. It wasn't identified by the routing team, by me.
Okay, so if there are questions about why the hog farm is a sensitivity, where would those questions best be directed?
To ATXI.
Okay, specifically, can Mr. Morris answer those questions?
Yes, Mr. Morris.
I appreciate that, and thank you, Judge, and Mr. Matthews for that latitude as well.
Okay, that's helpful.
Thank you.
Mr. Nichols, do you know who owns the hog farms?
I don't have first-hand knowledge of that. Again, I think that would be better directed at ATXI and their real estate people.
Mr. Nicholas, can you repeat that into your mic?
I'm
Sorry. That's okay.
I have this problem. Yeah, that's that's really not in my wheelhouse. It's more an ATXI and their real estate folks could answer that question better than me.
Thank you.
Okay, I'll save them until Mr. Morris is available. Thank you. I pass.
Okay, so no further questions, Mr. Matthews?
That's correct.
Okay. All right, Mr. Harding, do you have any questions of this witness?
Yes, Your Honor. Good afternoon, Mr. Nicholas. So did I understand correctly that any hog barn related questions, any hog barn property related questions should be saved for Mr. Morris? Is that correct? Or was it just that specific question?
The specific question, but you know, perhaps others.
I'm going to jump past the hog barns that you will see in the folder that my wife just passed out, but I would like to look at Exhibit 837.
Is this within the hog farm packet?
No, this is within. Sorry, when I amended that, I got.
If it's Exhibit 837, it does appear that it is in the hog farm barns packet. It should be the second page.
Okay. And it's 837. Okay. Thank you.
Okay, Exhibit 837 is, I believe, all taken from JND1, Mr. Nicholas. Going to the second page is Chart 5 from your JND1 document. It's, if everybody has found the Exhibit 837. And when you look at that, and I believe this is part of the comparison that you did of the first 27 lines that were developed for this project. before the open houses.
Okay, and that's, does that, you said it's page 2 of 837, is that where at the bottom it says page 19 of 51?
Yes, Your Honor.
Okay, so that's several pages into the packet for everyone else.
Okay, so I'm looking at from J and D1, which is labeled in the bottom right-hand corner, pages 19 of 54, page 26 of 54, page 17 of 54, and page 18 of 54. And I would like to begin with page 26 of 54.
Okay.
Can you give us just a second, Mr. Harding?
It looks like the page 26 is a graph with blue and orange in it at the top of the page.
So I'm going to begin on page 26 of 54.
Okay. Thank you.
So, Mr. Nichols, I read the process that you go through to locate and identify segments and to turn those segments ultimately into routes. And so I studied that a fair amount. It was obvious to you as well from reading your notes that DO1, DO2, DO3, and then DO27 were significantly superior when you look at the combined score data on chart 5. And so I wanted to know why that was. So I looked at those three, and if you go to page 17 of 54 and page 18 of 54 in JND1, what you notice is that all 4 of those routes have a commonality. They both begin with the segments AN as a beginning, and they're the only ones that begin with the segments A and N. So I went back to the segment map, which is found on page 19 of 54. And what I noticed is when you use the AN combination, those 4 superior routes all used the same location at the Gentry-Worth County line, that being on the hog barn property, where it makes its adjustment as it's coming north and as it turns west. For that short stretch, it's on hog barn property, and then turns back north again, leaving the hog barn property. So it's on there for a half a mile. What I want to know is, and I believe in studying this, the project was done extensively over a long period of time, even dating back to late 2022 through 2023. These routes were developed. How is it that the ownership of the hog barn property wasn't known until after the open houses in Grant City?
I don't think it's correct to say that the ownership of the hog farm property wasn't known until after that. I think the ownership was known, but the restrictions that might be placed on development and maintenance of a route by the owners and the use of that property as a USDA hog farm, that was the issue that came up.
Are you familiar with any particular restrictions or requirements at this facility?
No, that's not a question for me. That's for Mr. Morris can best answer that.
Okay. Well, we've established that nobody has communicated from the owner or the managers of this hog barn, and I have some familiarity there, just why I ask. Are you aware of any lagoons when you were doing your investigative study? You said that you may or may not have known of the owners of them, but you became aware. Clarify what you did know and what you didn't know at the time you created routes DO1 through 3 and DO27 with regards to the restrictions that were in place on the hog barn property.
I would object to the form of the question, but if you follow, perhaps you can answer, but if you are confused, I would encourage you to so state.
It seems a little open-ended. Can you clarify and focus a little bit?
Yeah, in trying to determine what you may have found out after the open house meetings that you didn't know at the time you created these 4 superior lines. If you could speak to that.
Specifically for the hog farm property?
Specifically for the location, yes. The location of the hog farm property.
From recollection, I don't think we were, or I was aware of specific restrictions in the way we're discussing them now for the hog farm property at that point when we came up with those routes.
Can you tell me how you became aware of those restrictions?
Through discussions with the rest of the routing team, ATXI.
And what did the routing team provide to you that made you aware of these types of restrictions?
No written documentation, but it was discussed on our, regular communications.
Nothing specific that you recall as far as a specific restriction?
Just generally that construction and maintenance of transmission facilities on that property would be problematic, and I should consider it a constraint.
But you can't offer any specifics today on what those considerations that you should take into consideration were. What did they tell you specifically to avoid? In one place I read that there were concerns over lagoons. Are you aware of any lagoons, old lagoons, near the proximity of where your line would go on this property?
That's the first time I've heard about lagoons.
I want to direct your attention to Exhibit 828.
Mr. Harding, would you like to offer Exhibit 837 to be admitted?
Yes.
Are there any objections to Exhibit 837?
I would object to it being offered as a part of this cross-examination. I believe that's a schedule that's already been offered for admission under an Ameren exhibit number, so I think for sake of clarity and for the record, if we could admit it there, I would have no objection.
Sustained. You may proceed, Mr. Harding.
The heading for you to find them in your folder will be under linear feet comparisons.
What exhibit is it? I apologize.
828,
828.
I believe, will be the front exhibit with a header on it that says linear feet comparisons.
Thank you.
It contains more than one exhibit. It's got 828 and 840.
Okay. Okay, you may proceed.
I'm jumping out of order, so I would like to jump back to the last part of that, which is Exhibit 840.
Okay.
And that is an FS data request 0053. And you can see on the front page of the data request, actually I'm looking at the response, Mr. Nicholas, that you provided. The linear feet, 2, 3 owners. Underneath of owner, there are 3 families mentioned or houses mentioned.
Do we need to go in camera for this?
I can keep it so you don't, if you would prefer, whichever you would prefer, Your Honor.
Does the
I won't
company have
mention
preference?
names.
Yeah, we can give it a try. Yeah.
I won't mention names.
Sure.
Because everybody has the reference, if you look at the 3 owners that they're clearly identified there, and it provides the linear distance from center line for those residences. Do you have any familiarity, Mr. Nicholas, with the middle one, which is the one in the center that is provided 1,244 feet? Do you have familiarity with that house at all?
Well, I don't specifically remember it, but clearly I did do this measurement.
Do you know about whether or not anybody has lived in that house recently?
I have no knowledge of that.
Was it a consideration in your routing?
The consideration in the routing was whether there is what appears to be a residential structure there or not whether it's occupied or whether it's recently occupied or what have you. If it appears falling down, we would note that.
Did you put any preference or weight value on ones that were occupied versus one that is not occupied when you were evaluating a route?
No, because we had no way of ascertaining whether a specific residence was occupied or not at the time.
Would that be something you would try to learn at an open house setting?
If somebody volunteered the information, sure.
If you saw a house and nobody volunteered any information about that house, is that something you would want to know before you placed a line in a particular location?
Specifically, would I want to know if a house was occupied or not?
Yes.
That's a little bit problematic because occupied might mean occupied at the time the routing study was done or occupied at the time of the open house. That doesn't mean to say it won't be occupied in the future or in the very near future or was very recently occupied. So there's some nuance to that. I'd be a little bit uncomfortable saying, we prefer routing next to unoccupied houses for those reasons. So we tend to treat them all equally.
Would you be interested if you came into the knowledge that a house had been a long time unoccupied, that being 5 years? Would that affect your consideration for that particular structure?
Again, I think that falls into that problematic phase because, again, maybe someone is thinking about renovating the house, very soon, owns it. I think that would be possibly a little unfair on the people who own the house.
Mr. Nicholas, did you make reference in your direct testimony and in J&D1 to newer residences north of 46 Highway?
Can you show me what you're talking about?
It's in J&D1, and it will take me a while. It will be formatted with the number column on the left, so look for J&D1 or direct where it's discussing the 3 bullet points. So you're looking for the 3 bullet points, which will be contained within. Mr. Nicholas, are you familiar with the 3 bullet points that you used as reasons to reroute that are contained in your J&D1 document and in your direct testimony? You refer to 2 bullet points.
Do you have a page number in?
No, I have not found it in my notes yet because I didn't bring the entirety of your document.
I think if I'm looking at the right one, Mr. Harding, is that from your hog barns? And it looks like Exhibit 837, and it's at the bottom, Schedule J&D1, page 29 of 54.
No, it's not there. Let me just have the page number. It's in, no, it's okay. Is that at 3 bullet points or 2? Yeah, it's 3. So it will say, if, Mr. Nicholas, if you refer to page 29 of 54.
Yeah, I have that page.
Okay. And within the 3 bullet points, what are the 3 bullet points that you used for justification for the reroute?
You want me to read them?
Well, I want you, off of memory or however you'd like to do it, paraphrase, but was one of them proximity to newer residences north of 46 or something similar?
Yes, the 3rd bullet point begins proximity to newly constructed residences.
Okay. Now I want to revisit your analysis and how you concluded what you did with regards to the particular property that we're looking at in Exhibit 840. And I ask you about the middle one that's listed there in that data request response.
I'm not clear about what you're asking me.
I'm asking if the middle house on this property, if the age of it matters when I look at what you, in context, to put that question in context, you paid attention to the age of the houses in your 3 bullet points as reasons to reroute this line. If it says newer residences, I read in one of your testimonies where ATXI claims that this house that I'm asking about is not a newer residence. And I wondered if you considered that in your evaluation.
I think the short answer is no. I think what we're dealing with, a residence is a resident, whether it's a newer residence or an older residence. A residence is a residence.
Now, if we could look at Exhibit 828. Within 828, within Exhibit 828, you should have a photo of 1 through 6, a full-page photo with some numbers identifying some properties.
I don't know where I'm looking yet.
I'm holding it up if you'd like to see that.
Which of the 3 packets is that in?
It should be in the linear feet comparison packet. It should say N29 in the bottom left corner, I believe.
Yes, Your Honor.
Yep, I have it.
This is an image from Google Earth. It has the identifier of 46 Highway going along here. It has the identity of the houses that are referenced, similar to Appendix E, Figure 10. It also includes houses that were overlooked at the time that you were doing the evaluation to reroute DO28. You might recognize the one that you overlooked as number 4 in this picture. Do you see number 4 in the picture?
Yes, I see number 4.
I would object if we could focus on questions as opposed to statements. I think it would be helpful here.
Overruled, as he did answer the question, but Mr. Harding, take that into consideration. You need to ask questions of the witness, not testify.
Exhibit 840. I was setting some background, Your Honor, I apologize, but Exhibit 840 lists some feet distances between houses. And I want to go back to 828 where the photo exists, and that photo is for context and reference purposes if you have any questions about the questions I'm asking about. But if you go to the last page of Exhibit 828, I ask in a data request for the linear feet from certain residences. The residences that I ask about are in the picture that we just talked about. Do you see your answer to A1 and A2?
I don't know what document I'm supposed to be looking
Just it says page 2 of 2, JN31. the bottom
Correct.
left? Okay.
That's correct. It is Harding Data Request 36A. And it's the last page of Exhibit 828. So 828 is in the top right corner, and we're looking at the last page for the answers to my questions. And within your answer, you basically described the question that I had asked. So I want to make a quick comparison between those linear feet distances to one newer residence north of 46 Highway compared to other residences that you had referred to in Appendix E, Figure 10 of JND1. And I wanted to ask you if you were aware of that, the linear feet distances to those residences at the time that you made your routing decision to abandon DO 27 and go to DO 28.
I'm not sure it's yet an objection, but can I ask a clarifying question? Is the question whether he was aware of the linear distance from the proposed line to the 6 structures identified on this map?
Yes, the last page of Exhibit 828 provides the linear feet and distances to houses 3 and 4. Those are the houses that are impacted by some variations of the DO 28. The current version of DO 28 that's on the website today goes between houses 4, 5, and 6. So I'm asking Mr. Nicholas if he was aware of the linear feet distances of each of the DO 28 location, which is between 4, 5, and 6 on this house, on this map, versus the linear distance between 1 and 2, houses 1 and 2, and that those linear distances can be seen in Exhibit 840 on the front page. Were you aware of that?
So you're asking me if I'm aware of the distance
At the
from-
time that you decided to reroute, at that time when you made that decision, did you have this knowledge in your hand?
We were not aware of residence number 4 at that time.
Were you aware of residence number 5 and 6 at that time?
I believe so.
Did the fact that you were placing the line closer to those residences, significantly closer, was that a consideration when you chose the place that you crossed 46 Highway?
I would object to the characterization of significantly.
Rephrase your question, Mr. Harding.
The distance from houses 5 and 6 is approximately 700 feet from the line as displayed on the interactive map today. The distance to house number 4, which you were not aware of at the time you rerouted, is approximately 500 feet. Even ignoring the fact that you didn't know the house was there, which in my opinion doesn't eliminate the problem associated with it, were you aware of the distance to 5 and 6 compared to houses 1 and 2? Did you ever have field notes or any evaluation process that revealed that information to you at the time you made your reroute decision?
When we assessed the houses and all the other criteria within, a certain distance of DO 28, yeah, we would have been aware of that, yes.
You were aware of it?
Yes,
Okay.
I believe so.
Do you remember me calling you in October of 2024?
I remember you calling me, yes.
Yeah. Do you remember the nature of that conversation? Do you remember what I called about?
I believe, and this is not particular recollection, but notes since that have reminded me you were discussing that we had perhaps missed house number 4.
Yeah, I brought to your attention house number 4 had been overlooked. And did I send you an email?
Yes,
Yeah. Did I send you a follow-up email?
yes.
Did I send you another follow-up email?
I can't be sure of that, but I will take your word for it.
Yeah. Did you receive any phone calls from me that you did not answer after that?
I don't recall, maybe.
You didn't answer, so there was no phone conversation that took place. Are you aware of me calling you?
I just don't recall.
Did you ever email me back?
I don't recall if I emailed you back or not.
You did not, as I recall. Did you ever call me back?
I did not.
Okay. That was what I wanted to bring to your attention. I thought it should be addressed a year ago.
Mr. Harding, please ask questions of the witnesses.
Yes. Mr. Nicholas, I'd like to direct your attention to Exhibit 801.
Mr. Harding, do you wish to offer Exhibit 840 and 828?
Yes, Your Honor.
Are there any objections to Exhibit 840 and 828?
There are no objections, but I do have the same concern. I would like to be able to redact the names of the individuals who live at those residences. We were able to avoid it, but I did notice they were written in, so I wanted to make sure.
And that was, is it 828 or is it 840 as well? That has, I think both do have the names.
I know.
I think the last page of 828 also has names on it.
840 appears already to be marked confidential, so I think we do have a redacted copy already on EFS.
Okay.
And Judge, I
Yes.
would say I likely have objections, but if you can give us a minute maybe to work through copies to make sure that I'm looking at the same thing that everyone else is, I think that'd be helpful.
That's fine.
All right, you're 840. Good? Good. All right, good there. So maybe take these piecemeal. In terms of Exhibit 840, we would have no objection to what I would call a clean, confidential version going into the record. There's some notes on this that I don't believe are from Mr. Nicholas, but if those can be removed, we would have no objection to 840.
And that just a confidential version?
I think it has.
Oh,
if
I wasn't
rem-
sure.
I think that's right.
Yes, Okay.
It is right.
We can make a public version if necessary, because.
I think it's fine.
Okay.
Thank you. I just wasn't sure if there were multiple, and you said it's already, I think Mr. Ringel said it's already on. And for 828,
I see your version. Second.
Your Honor, can I confirm that your version of 828 that would be entered is a 4-page entry?
I believe that's the version I have. It has, the first page says JN28, then N29, JN30, and JN31 on the bottom left corner of each of those.
I did notice that page 3 does have a residence.
Yeah, one of them
So-
at least does.
Yeah.
I know there are some names written as
Yeah.
well.
There are some names written. We could do a clean copy of that, but even if we did that with the third page, it does look like there is a residential name. So I just wanted that to be noted.
If we can resolve those issues, the company's likely okay. We don't have an objection to the company's response to 36A coming into the record.
Okay. And you want a clean copy, though? Not the handwritten one?
Please. And I'll admit I'm not quite sure what to do about the confidentiality piece.
I think I'm missing on page 1 of 2 where there'd be confidentiality. Oh, I see it. It's in number C, right? Is where the name is.
C,
Oh, C and B.
and
Yeah.
all three of them, yeah.
Okay. Yeah, so an unaltered confidential version.
No objection to that, Judge.
And, sorry, are we offering a public version as well on that, or just marking the whole exhibit confidential?
The entire exhibit can be confidential from my standpoint.
That's fine with us.
Okay, that's probably simpler. Okay. You can proceed, Mr. Harding, and if you can, you mentioned an exhibit name. I did not hear it before going through this.
Exhibit 801.
Which packet is that in? Oh, it is in the Hog Barns packet.
Yes, I apologize.
That's
when
okay.
I abandoned the hog barn idea. Okay. It should be also in your proximity to houses portion, Your Honor. It's Exhibit 801 in the top right corner.
Okay.
It's page 21 of direct testimony of James Nicholas for another reference, and I will be referring to page 2 of that exhibit, which is from its ATXI's response to staff recommendation docket item 64.
So this is only in the proximity packet that you're referring to now?
Yes.
Should say 12 at the bottom, correct? 2 of 2 in the top right corner?
Correct. As item 26, displayed on the left, paragraph 26. Are you familiar, Mr. Nicholas?
Yeah, I have those in front of me.
Yeah. This is more recent, so hopefully that's more helpful. Looking at that page 12, the second page of Exhibit 801, you make the comment that I'm in paragraph 26, about 5 lines down. It starts with ATXI, and it says that ATXI wants to note, while the existence of that house that had been overlooked, you would like to have known, this fact wouldn't have changed your routing recommendation. How are you able to make that determination after the fact?
Well, we have the information after the fact that there is a residence there, and the fact that that residence there does not change materially the viability of that route.
So did you reevaluate after learning about this residence?
We took that residence into account when we looked at that route.
Did you reevaluate overall the route comparison between the route that you'd abandoned DO 27 when you decided to go to DO 28? Did you reevaluate? Like, do you have notes on that reevaluation after learning about this on October the 20-something of 2024?
It's described in testimony, I believe, that we reevaluated, and there was no material reason not to use DO 28 based on the addition of that one house.
Do you have any notes? Did you come today with any notes, or do you have access to any notes where you did reevaluate after learning about the house in October of 2024?
I do not have specific notes to that effect. I have testimony to that effect.
Then I want to ask further down, about 4 lines down. It begins again with ATXI, and this is Mr. Nicholas speaking. I believe that ATXI submits that even on a standalone basis. And then you describe a route with 3 houses approximately 1,000 feet from the line is not objectively better or more desirable from a routing perspective than a route with 1 house 500 feet from a proposed line. Is that a hypothetical scenario, or is that an actual scenario that you're describing there?
I just need to read this. Excuse me. So can you repeat the question?
I'm sorry?
Can you repeat the question, please?
Yeah, you want me to read it again?
I just want you to ask the question again.
Okay. Is that a hypothetical scenario that you've laid out there, or is that an actual scenario?
I'm not, as I sit here, I'm not sure if it's hypothetical or actual.
You don't think you were making a reference to the actual houses that we just discussed,
It's possible.
but you don't know?
But I don't want to tell you something 100% when I don't know if it's 100%. That's all.
Okay. Do you think that this route has 3 houses approximately 1,000 feet from a line, and also the alternate route to that route has 1 house 500 feet from a line? Do you think that scenario exists in this decision between DO7 and DO28?
I think you need to clarify the question a little bit. I'm not sure I understood it fully.
You're writing this response to staff recommendation, and at the time you're writing, you're explaining why the house didn't matter to you so much that you hadn't noticed. And so you paint a scenario which I assume applies to this decision that you were making at this time on this project for these houses. But if I'm wrong, I want to give you an opportunity to explain where I'm wrong.
I would jump in and object to the form of the question, and I believe that that mischaracterizes what Mr. Nicholas has said.
And I want to give Mr. Nicholas the opportunity to clarify, so I'll restate the question, Your Honor.
Please do.
That statement, 3 houses approximately 1,000 feet from the line, is not objectively better or more desirable from a routing perspective than a route with 1 house 500 feet from the proposed line. That's your writing, and I'm asking if that scenario was the scenario that you faced in this case.
Probably, yes. I would have to go back and look at all the data just to make sure, but probably, if I'm writing that.
Well, if you're probably right, what are probably the 3 houses that were within the 1,000 feet?
I can't tell you that off the top of my head.
What was probably the house that was within 500 feet? Do you have a guess to that, what you might have meant?
I would have to go look at the mapping just to
Would
make
it
sure.
possibly have been the house that we just looked at in that picture, this item 4, that you overlooked?
Which?
The house that
number
you,
4?
we'll just call it the house that you overlooked. Is the 500-foot reference the house that you overlooked?
I would have to look at those measured distances again just to make sure it was within.
This is
500
your
feet.
writing, and you said 1 house within 500 feet from a proposed line.
From a proposed line?
From a proposed line, yes.
Yes.
That's your words. Is that a reference to the house that we are talking about in this case that you overlooked?
I would have to go and look at the data that we measured.
So you don't know?
I'll object at this point as asked and answered.
Sustained. And Mr. Harding, please allow the witness to answer your questions before asking another question. And please don't interrupt the answer he's given. Do you have any other questions for the witness?
I do, if that's the answer is I don't know, that's the answer. One moment, Your Honor.
Did you wish to admit or offer Exhibit 801 to be admitted?
Yes, Your Honor.
Are there any objections to Exhibit 801 being admitted into the record?
I would object to this form of 801. I believe that this is an excerpt from Mr. Nicholas's testimony, and we've offered that for admission. So for sake of the record, if we could have it
I
included
withdraw my
there.
request.
Okay.
Drawing your attention to Exhibit 820.
Which packet is this in, Mr. Harding?
Still in the same proximity to residences section. Exhibit 820 in the top right corner. It's data request 13.
It's in the front or the back of the packet?
I apologize because I've jumped around now. It's towards the back. Well, no.
Looks from what staff has, Judge, it looks like should be the immediate page following the document that Mr. Nicholas was just being questioned about.
Okay. Oh, I see it. Sorry. Thank you. You may proceed.
It's Exhibit 820, and I want to ask about Mr. Nicholas's response. I had asked Ms. Detmers earlier and was instructed to ask Mr. Nicholas at this time about this. It's about the field review, Mr. Nicholas, that was done in this area that you claim was done in April or May of 2024.
I'm sorry, I don't have 820 as far as I can tell in this packet.
It should be right after the testimony portion we were just on. So the page 12, it was 2 of 2, and then it's the next page.
We don't need the exhibit if Mr. Nicholas just wants to answer. It's, did you conduct a field review?
And I do want to ask, I think Exhibit 20 has been offered and admitted. Is this a different page number, page 1? How does this work with?
Your Honor, what it is we have entered the same exhibit in Ms. Detmer's file as we are, and we have it in 2 locations, so that's
Okay.
why it's a duplicate.
So it's
to
the
you.
same?
Yeah.
Okay. Just wanted to clarify there wasn't an additional page
Yeah,
or
it
anything.
will not be needed to be entered. I was just going to ask Mr. Nicholas, because Ms. Detmers was not the appropriate person to ask.
Right,
About
okay.
this field review that was conducted in April or May. This would be at the time the decision was being made to relocate DO 27 to 28. What can you tell me about that field review, what all it entailed?
So we typically conduct a field review for any routing study we do, and it typically encompasses the entire study area. So the purpose of that is to really look to see if we miss large-scale features. The data we have these days is really good. You know, we have some fairly recent aerials, we have online databases we can research, but there is a lag time between the most recent aerial photographs and databases and what's there right now. So what we're really looking for when we do that, and we do it across the entire study area, is to figure out if there are things that have happened since we did our original mapping, things like housing subdivisions, someone's built a wind farm, that's happened recently. So we're looking across the entire study area, not at specific locations, to update the general land use of the area.
Was there a field review done specifically between the time of the open house and the inception date of DO 28, that being May 15th, 2024.
The field review I'm referring to was conducted just before the open house.
At that time, were you considering a route location that is now known to be DO 28?
Not specifically, no.
I want to look at Exhibit 837 in the same proximity folder. Exhibit 837 and Exhibit 841.
This one is towards the back. It's a map, 837.
Yes, they depict maps. One is a map from appendix, excuse me, it's figure 10 from JND1, and that is Exhibit 837. And Exhibit 841 is a part of a data request 0032.0, page 1 of 10.
Sorry,
Yes.
I am so sorry. This is going back to an old exhibit. I think I just noticed on 820, I do think they also have names, so that was just something I just wanted
Yeah,
to know.
there, I think it's listed as confidential
Okay,
and a
great.
public version.
Okay, good.
That's what I have
Awesome.
in my list. Thank you.
Mr. Nicholas, the imagery date on Exhibit 837 is in the bottom left-hand corner. And I'm just using this because it was already available. The figure 10 is taken from the application, Appendix E. I just wanted to ask you a question about the imagery date that you used at the time of the DO 28 inception and decision process, being February and March of 2022. Do you know why you used imagery in May of 2024, why you used imagery from February of 2023 or 2022 for that, for the purposes of identifying things, I would presume, when you're trying to locate a line?
So I can tell you why we used this imagery then. So we use an ArcGIS-based platform to do routing and mapping, and we stream aerial photographs to that. Those are typically pretty up to date, usually not more than a year old. So when we originally did this, we were using that 2022 data. And as you scroll across and zoom in, the date of those aerial photographs can actually change depending on, you know, the source and resolution of the streaming data that's put on there. So, you know, for whatever reason, you know, the data streamed to us was February 2022, and you know, that newer aerial photographs can be added at any time, just not by us, by the streaming vendor, which in this case is probably Esri. They control the streaming data on that. It's usually very good. It's very good resolution. It's the latest, easily available to us at the time. That's the source we use.
Was it your choice, since you can zoom to different levels, as I understand it? Did you zoom to different levels when you were investigating the route that you were ready to relocate to?
Yes.
Did you pay attention to the imagery date, and did you notice things did you find an imagery date that would reflect perhaps a house that was overlooked that had been there for more than a year?
I mean, we always pay attention to imagery dates, and we'd love to use the latest available to us.
Yeah, I would think so. Let me draw your attention now to Exhibit 841. This is a data request response approved by you, Mr. Nicholas. And again, I want to, if you find Exhibit 841, it's a photo that's taken from EFIS. This is a data request that was made and you responded in December of 2024 to this data request. And the date stamp is in the bottom right-hand corner, that you are the one that approved this image. I noticed that the imagery observed on this particular photo is 12/23 of 2024, and you were working on this in December of 2024. I'm wondering why you use such current imagery, or did you notice the age of the imagery when you did either of these? Is it something you pay attention to?
Yes, it is. So this was produced later, and so the streaming date is later. It was produced by a different person as well. Not that that has any particular bearing on it. I, by the way, can't see the date on this. It's not visible to me.
The observed date in the bottom left corner?
It's not here.
Oh, I showed 12/23 of 2024. Would you like to see my copy?
No, I can take your word for it. It's not uncommon for aerial photos to switch, in the streaming platform.
And also, this can be found on EFIS under data request 0032, so it will be more clear there.
Mr. Harding, would you like to offer Exhibit 841 and just mark it as confidential?
Yes, Your Honor.
Are there any objections to Exhibit 841?
So I don't have an objection to the full data request and full response coming in, but I would object to the standalone image here. I believe that this is a response to a broader question.
I withdraw my request, Your Honor.
Okay.
Mr. Nicholas, I want to draw your attention to Exhibit 825.
Which packet is this in, Mr. Harding?
This is still in the proximity to houses folder. If I could, before I take you there, I want to draw your attention to Exhibit 811. It's a photo that accompanies what we just discussed. Exhibit 811 is just a photo and another photo behind it.
Is that also in the proximity packet?
Yes.
Okay. I'm not seeing 811. Anyone help me if it's in the beginning? Oh, it's the same one. Okay.
Yeah, holding it up now, Judge. I think this is 811.
Thank you.
But if someone could help me find 825, I do not see that one.
I do not either.
825 is contained within Harding Data Request 18C that was visited in Ms. Detmer's.
It's in Ms. Detmer's testimony, not packet, exhibit packet, not in Mr. Nicholas's?
It is in Mr. Nicholas's also, and
Okay.
it should be.
And what's the name of that DR again, Mr. Harding?
D18C, Harding 18C. I apologize because we're talking two different things now, but I got one thing ahead of the other.
I thought it might be that one. Is it cut off on the top if everyone has it? There was one that has an 8-2.
Your Honor, if I could approach.
Yes, you
I
may.
think that's it. I think that's it.
Just gotta find it now. Yeah, okay. This one. Okay. Yeah, the page following. Okay, thank you. So it should say JN 19 and JN 20 in the bottom left corner, if that helps anyone else.
If I could, just to finish the line of thought that I was on, Exhibit 811 is some imagery dated 7/14 of 2024. If you see that in Exhibit 811. Yes.
Yes, I can see that.
Mr. Nicholas, had you have used imagery somewhat current, this would have been the view that you would have seen. Had you seen that view from imagery, would it have changed your considerations when you were deciding to reroute from the DO 27 to the DO 28, given that one of your bullet points was to avoid newer residences on the north side of 46 Highway?
No,
Okay. Now I want to look at Exhibit 825.
I just don't have 825, I don't know.
It says 8-2, it should say JN 19 on the bottom left, if that helps.
It's an
package are
overlay
you in?
map, and it's two images.
Proximity to houses should be the packet.
This one? Oh, yeah, I've got it. Thank you.
Do you recognize this is an overlay of Exhibit 800? This overlay can be found in Harding DR 18C. It was a response that ATXI provided 2 photos in my data request, 18C. You'll see it here as Exhibit 825. It contains 2 photos. Exhibit 800 is the one I'm holding up and is the one found on Leah Detmer's invitation to the open houses. If you have Exhibit 800,
Mr. Nicholas, it should be page 1 of that same packet, proximity to houses. I guess page 2, the first, after the cover.
Oh. All right, got it.
for references purposes, if you would look at Exhibit 800 for reference, do you identify within Exhibit 825 the first photo as being a close-up photo of Exhibit 800 or an overlay of that map?
Yes,
If you look at the second photo of Exhibit 825, do you recognize the shaded area in the center of that photo between 2 residences as being a closer version of the first photo in Exhibit 825?
yes.
Thank you.
Mr. Harding, would you like to offer Exhibit 811?
Yes, Your Honor.
Are there any objections to Exhibit 811, 811?
I'm not even sure, Your Honor. Is that a portion of your surrebuttal testimony? Is that from your surrebuttal?
Is that where that came from? Yes. I'll withdraw.
Okay.
For expediency.
Okay, how about 825?
I would like to enter 825, both pages, Your Honor.
Is there any objection to admitting Exhibit 825?
It's a response to my data request.
Give me one second, Your Honor.
It's also confidential.
So 18 is the full. See if this helps. So this portion of 825 is a portion of a data request that has a much longer response, some of which is confidential. But I guess if it would satisfy you, I mean, we would, consistent with Mr. Nicholas's testimony, we would stipulate that this image and agree that this image corresponds with the image contained in Ms. Detmer's testimony. Is that satisfactory?
Yes, there's 18, 18B, and 18C. Would it be more appropriate to include the entirety of my data requests to reflect the entire exchange?
Well, I'm struggling a little here because let's see, it looks to me like Ms. Detmer's sponsored DR 18, Harding 18. So I'm not quite sure where to go with that or the substance of it, but I don't believe that Mr. Harding has laid appropriate foundation for the admission of that through Mr. Nicholas. I don't know what he does or doesn't know about this DR. If we're talking about the image, I think there's a way to get there. But in terms of the substance, as of right now, I would object.
Is it possible the 825 is just the two images? Would you have an objection to that? Just as an exhibit, these two images?
Are you okay with the handwritten descriptions here? I mean, they're referencing some residences on your text. I don't care if you don't.
I would eliminate that. I would clean it up and provide for the court
Yeah.
clean version of the two images alone.
I'm okay with that. Yeah, no objection.
An altered version? Okay.
Yes. Make a note of that.
Okay.
Mr. Nichols, and there's an exhibit in your portfolio, 837, and it's where you compare the DO-27 to the DO-28 routes. Perhaps you're familiar with that comparison evaluation. When was that evaluation done?
Can I get to the? You said 837?
837, yes.
Is this, say, page 30 of 54 on the bottom right?
Yes, Your Honor.
Okay. Towards the very back. There's a couple pages left. Proximity
Looks like I might be missing that page.
I hate to do this in the middle of a question, but recognizing that Mr. Nicholas has been up for a little over an hour, can I at least ask maybe about how many more questions you have, or any estimate of
This
time?
is my final question.
Okay, yep, very good, thank you.
And I'd like to recess after this, if that's okay.
Very good,
Mr.
thank you.
Nicholas Bree.
So which page were you asking about?
It's Exhibit 837 in the top right corner. This is from JND1, page 30 of 54 in JND1. It's a comparison between DO27 and DO28. And my question is, when was this comparison done?
Did you say page 30 of 54?
30 of 54, yes.
Found it.
If you know about when this study was
Yeah,
done.
shortly after the public meetings and, yeah, shortly after the public meetings.
Late April, mid to late April.
Around that time frame.
And you did not know about one of the residences at the time of this comparison. Would that alter this comparison at all?
I would object as asked and answered.
Overruled. If he knows the answer.
Would the addition of one house change this comparison? Is that-
Yes.
No, it would not.
Okay. And I read JND1, and you make note of PFO wetlands. It's the fourth one from the bottom. And in JND1, you describe PFO wetlands as the only wetlands that are an issue with transmission line placement. It's noticeable that the DO28 has 15 acres versus 5 acres for the DO27. Do you have familiarity with what is required to address the PFO wetlands that you will encounter with DO28 that would not be encountered with DO27?
Yes, there would likely be some additional permitting and some additional mitigation for that one issue.
I have no further questions.
Okay. Thank you, Mr. Harding. Thank you, Mr. Nicholas. We'll take a brief recess until 2:05, and we can reconvene then. Record. I believe that it is crossed by McKinley Farms.
Yes, Your Honor. May I approach?
Yes, you may. And before we proceed with this, I want to address, we did not give a spillover day. So it's 2 p.m. We have, I think, 5 more witnesses after this. So be cognizant of that if we need to stay late in order to proceed. Go ahead, Ms. McGinley, or counsel. Sorry, Ms. Bell.
I'm handing the witness what's been marked 952.
Thank you.
Good afternoon, Mr. Nicholas. I'm Stephanie Bell. I represent Ms. McGinley in this case. Do you recognize 952C?
Yes,
Is that a DR sent by Ms. McGinley that you prepared the response to?
yes.
Okay, and I will note for the record that it is, the actual attachments are confidential. Can you tell me generally what this DR depicts when we flip the page?
So one question, I don't recognize the pins on here. Were they part of the original?
They were. I'll read from the DR response for you. It says, please see the attachment for a preliminary sketch of pole structure locations. Would it make sense to you that those yellow pins depict pole structure locations?
That would make sense to me.
Okay, and then if we're looking at that first page, following the response, are you familiar generally with the McGinley parcel?
Generally, yes.
Okay, and so, so since you're familiar with that, the structure located up toward the north side of that parcel, is that your understanding of the McGinley residence?
The residence located just to the east of that, is that what you're referring to?
Correct.
Yes.
Okay, and so you would agree with me that the company's original proposal as well as their modification to would both mean a structure located on the McGinley residential parcel there in the southwest corner of her parcel, correct? Yes. You're
Yes.
pointing to a yellow pin.
Yeah, pointing to a yellow pin at the intersection of H and whatever that east-west road is.
Okay, thank you. Now, I understand you have a copy of your testimony in front of you.
Yes.
I'm looking at 11C, which is the confidential version of your rebuttal testimony. And, Your Honor, for your purposes, we are going to attempt to steer clear of confidential information, although I am working off of the confidential version. Can you flip to page 3 for me, please?
Yep.
All right. When you were discussing the selection of DO 28, do you see on line 18 where you said you made part of your routing process was to follow property lines and roads? Is that correct?
That's correct.
Okay. And that's part of the best siting criteria that you use. Is that correct?
That's part of typical siting routing practice.
Okay. And I handed you the packet that I handed out during my opening, I believe. Do you have this copy?
I don't have that with me.
Okay, I'll hand you that. So Schedule MS3, which you now have in front of you, which was attached to Ms. McGinley's direct testimony, you would agree with me that for the 3 McGinley parcels impacted, you did not follow property lines and roads, correct?
That's correct.
If you flip to page 14 of your testimony. you there?
Yep.
Okay, on lines 5 and 6, you say that DO 28 parallels an existing transmission line across all the parcels owned. Is that correct? You see that?
I see that.
Okay. Now, when you say the word parallels, is it your understanding that the easements would not be the same?
So, yes, in this case, paralleling means paralleling and not overlapping easements.
Okay. And so the lines wouldn't be co-located on the same structures, correct?
Correct.
So we're talking new lines, correct?
Correct.
New structures, correct?
Correct.
And 2 separate easements, correct?
Correct.
You would agree that just because there's an existing transmission line across a property, that the property owner didn't necessarily agree to that initial line, correct?
I don't know how to answer that question. The line had to be put there through some agreement.
Or an eminent domain process, right?
I wouldn't know.
Okay. Let's flip to page 15 of your testimony. I'm looking at lines 1 and 2. And there you're saying it's considered, I think for one of the reasons why the company proposed the route it did, you said it's considered poor practice to fragment properties unnecessarily. But I would like you to then turn to my packet of maps. And if you flip to the second page, MS4, and we look at the existing lines with the red dashes and your proposed route in a green line, you'd agree that you didn't follow existing pathways for the entire DO 28 route, correct?
Correct.
Did you estimate the cost of the McGinley modifications?
I did not. ATXI did, I believe.
Okay, but your testimony is that the modification would add just 150 feet and 1 additional turn to the route, correct?
Correct.
And that's page 8, for the record, page 18, lines 4 and 5. So you don't know what that cost is?
In dollar numbers, I do not.
Did you review staff's testimony in this case?
I don't believe I did.
Okay. Which witness from ATXI would know the cost of the modifications?
Maybe Sam Morris?
Okay. At this time, I'm going to offer what was marked as, I think it's 952C. That's the DR response.
Is there any objection to 952C being admitted?
No objection.
So admitted.
No further questions. Thank you, Your Honor.
Thank you. Are there any commission questions for this witness? I have one question here as well. Mr. Nicholas, you at one point it was mentioned, I think in your testimony somewhere, where it says that 1,000 feet is not necessarily the standard for distance from a residential home and a transmission line. What is it typically from a residential home? Could you say?
There's no typical, because it depends entirely on the context. Like if you can imagine, excuse me, routing a transmission line through an urban or suburban area where there's limited room, you may have hundreds of houses within 500 feet or right on the edge of a right-of-way. Or in a rural area, you're going to have far less, and you can be a little bit, you can have larger distances essentially. So that there is no standard. There are regulations, and then there are preferences not to take houses, right? Which would, if a house was within a right-of-way of a transmission line, you can't have that because of, conductor swing and all of that. No, regulations don't allow it. So that structure would have to be removed. So we do really attempt more than anything else to avoid houses or structures within the right of way if we possibly can. But there is no actual standard.
Okay, thank you. Now recross by the parties, beginning with staff.
No cross from staff.
Okay. The Office of Public Counsel.
I have no recross. Thank you.
Mr. Matthews, do you have any questions about if there's standards on the?
No.
Okay. And Mr. Harding, do you have any questions on that?
No, Your Honor.
Okay. And for Ms. McGinley?
No recross, Your Honor.
And now redirect.
Yeah, thank you. I'll be quick, Judge. Mr. Nicholas, if you have your direct schedule JND1 and could turn to page 30, I would appreciate it.
Page 30?
Correct. 30 of 54.
Yep.
You there?
Yep.
And Mr. Harding asked you some questions about this, correct?
Yes.
Yes, specifically questions around the difference of the effect of DO 27 and DO 28 on PFO wetlands, right?
Correct.
As evidenced by that chart, that's one input among many, right? Okay.
Correct.
And some of those inputs favor DO 27, and some of those inputs favor DO 28.
That's correct.
There was quite a few questions about the location of DO 28 and the proximity of the line to several houses. Do you remember that line of questions?
Yes.
Okay. One of those houses is the house that, for sake of public testimony, I'll refer to as house number 4. Do you remember that line of testimony? You know what I'm referring to?
Yes.
Okay. And I think it was your testimony that you said as a part of your field review, when you drove around the study area, you didn't see that house.
I did not.
Okay. But is it your testimony that if you had seen that house, if you knew that house existed, that your recommendation would be the same?
Correct.
Okay. How long have you been in the routing industry?
I've been doing electric transmission routing specifically for about 30 years.
Any idea how many lines you've routed?
Dozens.
Okay. Have you ever seen a perfect line in terms of siting?
There is no such thing as a perfect route.
Yeah. As you sit here today, is the route that ATXI, the DO 28, the route that ATXI has put before this commission for approval, in your professional experience, do you believe that's a reasonable route?
It's a very reasonable route.
Sorry.
I
I think it's within the commission's jurisdiction to determine whether the route is reasonable.
Is the question in his professional capacity, or?
It is, yeah, and I'm happy to restate if that helps at all.
Please do.
Sure, yeah, I'll start over. I guess my question is, in your professional capacity and given your experience as, a routing expert in this industry, do you continue to recommend that the commission approve DO 28?
Yes, I do.
Okay, and perhaps I should qualify that as subject perhaps to some of the modifications that were discussed in the company's rebuttal testimony.
Yes, correct.
Okay, no further questions, thank you.
All right, thank you. Mr. Nicholas, you may be excused. Okay. ATXI, if you'd like to call your next witness.
Your Honor, Christine Prorock, on behalf of ATXI, we call Chris Korsmeyer to the stand.
Okay, Mr. Korsmeyer, will you raise your right hand? Do you solemnly swear or affirm that the testimony you are about to give is the truth?
I do.
Right. You may proceed.
Good afternoon, Mr. Korsmeyer. Could you please state and spell your name for the record?
Chris Korsmeyer, Chris-Korsmeyer.
By whom are you employed and in what capacity?
I work for Ameren Services in the real estate department.
Do you have in front of you what is marked as Exhibit 12, the direct testimony of Tara Green?
Yes.
And do you have in front of you Ms. Green's supporting schedules, Exhibits 13, 14, 15C, 15P, and 16?
Yes,
And did you adopt her testimony and schedules in their entirety?
I did.
Do you also have what is marked as Exhibit 17, the rebuttal testimony of Chris Korsmeyer, and supporting schedule Exhibit 18?
Yes,
Were your rebuttal testimony and supporting schedules prepared by you or at your direction?
yes,
And with respect to your testimony, if you were asked those same questions today, would your answers still be the same?
they would.
And is the information contained in your testimony and schedules true and correct to the best of your knowledge and belief?
Yes,
Your Honor, at this time, I move for admission of the direct testimony of Tara Green and supporting schedules Exhibits 12, 13, 14, 15C, 15P, and 16, filed on July 16th, 2024, and would also move for the admission of the rebuttal testimony of Chris Korsmeyer and supporting schedule Exhibits 17 and 18, filed on August 14th, 2025. And with that, I would tender the witness for cross-examination.
Okay. Are there any objections to exhibits? Let's take them each separately, I guess, quickly. Exhibit 12, any objections? Any objections to Exhibit 13? 14? 15, confidential and public? 16? 17? 18? 19? And 20, confidential and public. Okay, so admitted. I think we begin with staff. Do you have any questions of this witness?
No questions, Your Honor.
Office of Public Counsel.
No questions.
Mr. Matthews, do you have any questions of this witness? Is *6 to unmute?
I have no question.
Okay, Mr. Harding, do you have any questions of this witness?
No, Your Honor.
And for McGinley Farms? I think you're muted. Yep.
Thank you. If you could flip to, I think it's Exhibit 17, rebuttal testimony. Do I have the number right? Okay. And you can flip to page 8.
Okay.
And at the same time, I think my packet of maps is still up there. You have this one? No? Did someone take it with them?
no, I don't
I'll
have
hand it to you.
Is this the page you're talking about? Oh,
8 at the bottom, or
Yeah,
I'm looking
8 at the
online?
bottom.
Okay.
And I can read it to you. So on page 8, you say that ATXI intends to fairly compensate landowners for the rights required for the transmission line, correct? You recall that testimony?
correct.
Okay, and sitting next to you is Schedule MS4. Do you see that map?
Yes,
And do you see how ATXI's proposed route runs very near well, okay, you're gonna object to that. Runs less than 1,000 feet from Miss McGinley's home. Do you see that?
I see where it's represented on the map, yes.
Okay, but you see that it's on an adjacent parcel, correct?
Correct.
So Miss McGinley won't be compensated unless ATXI goes over that southwest corner of her residential property, correct?
Correct.
But for the portion of the line that's near her home, she won't be compensated at all, correct?
The landowner will be compensated for the easement rights that is needed on their property.
Okay, and do you recall testimony about the Conservation Reserve Program? I think I'm on page 12.
Yes.
Okay. You don't have any land in the Federal Conservation Reserve Program, do you?
Personally, no.
Okay, and you didn't review the McGinley CRP contract, did you?
Not at this time, we have not.
Okay. No further questions.
Are there any commission questions for this witness? Redirect by the company?
No redirect, Your Honor, but I did want to note, for the admission of exhibits, I think it was only exhibits 12 through 18 that we moved to admit through this witness, not 19 and 20. So I just wanted to clarify that for the record.
Thank you. Okay, Mr. Korsmeyer, I believe you're excused. And ATXI, if you'd like to call your next witness.
Thank you, Your Honor. ATXI would like to call to the stand Sam Morris.
Okay, Mr. Morris, can you raise your right hand? Do you solemnly swear or affirm the testimony you're about to give is the truth?
I do.
All right, you may proceed, counsel.
Good afternoon. Can you please state and spell your name for the record?
Yes. Sam Morris, SAMMORRIS.
By whom are you employed and in what capacity?
I'm a senior manager of major projects employed by Ameren Services Company.
And are you in this case adopting the direct testimony of Tracy Denker, identified as Exhibit 19?
Yes.
And are you also adopting the accompanying schedules?
Yes.
And did you prepare for filing in this proceeding rebuttal testimony, confidential version, and a public version?
Yes.
And Mr. Morris, if I were to ask you the same questions that appear in the direct testimony of Tracy Denker and your rebuttal testimony, would your answers remain substantially the same?
Yes.
And are those testimonies, to the best of your knowledge and belief, true and accurate?
Yes.
Thank you. At this time, Your Honor, I would like to move for the admission of the following Ameren exhibits. Ameren exhibits 19, 20C, 20P, 21, 22C, 22P, 23C, 23P, 24, and those were all filed on July 16th of 2024. I'd also like to move to admit Exhibit 25C, which was filed on August 15th, 2025, and Exhibit 25P, which was filed on October 16th of 2025.
Okay. Sorry, I got ahead of myself earlier. Are there any objections to Exhibit 19? We'll go through those again. To Exhibit 20P and C, 21, to 22P and C, to 23P and C, to 24, and to 25P and C. Okay, those are so admitted.
Okay, thank you. I have no further questions, Your Honor. And Mr. Morris is now available for cross-examination.
Okay, beginning with staff. Do you have any questions for this witness?
Yes, Judge, thank you. Good afternoon, Mr. Morris.
Good afternoon.
Were you present at the in-person LPHs that were held in December of 2024?
Yes, I was.
And do you recall hearing concerns from landowners regarding clearance heights for the lines and their farming equipment?
I do.
Does ATXI address those concerns and typically address those concerns in its planning for transmission lines?
Yes, our lines are designed to meet all of the code requirements for the NESC. On top of code requirements, we include additional buffer for clearance in our engineering standards.
And with the code requirements and ATXI's engineering standards, what typically is that clearance height?
The minimum clearance height for a 345 kV line is 25 feet.
And then, do you also recall hearing landowners voice concerns regarding any damage to their property from the installation and maintenance of these lines?
Yes.
Does ATXI typically propose a plan to mitigate any damage to the property from installation and maintenance?
Yes, our plan, we would anticipate fairly compensating landowners for damages to their property, whether that be upfront payments for prepaid damages or actual damages after work is performed.
And those kind of plans, those are applicable to this CCN application as well, correct?
That's correct.
Thank you, Mr. Morris. No further questions, Judge.
Thank you, Mr. Pringle. Are there any questions by public counsel?
Just one, and it's to go off of what Mr. Pringle said. You said that you have plans to compensate landowners for damages that ATXI's maintenance and operation of the lines cause or may, you know what I mean. Has ATXI, to your knowledge, made any sort of payments to landowners for such construction and maintenance of these lines in the past?
Are you referring to similar lines, like other lines that we've constructed?
Yes, lines like the, transmission lines such as this one or similar, yes.
Yes, that would be a common practice for us for transmission lines that we construct or have constructed in the past and are performing maintenance on.
And do you have any mitigation efforts within the company to avoid those damages as well?
Yes, we try to plan our construction in using methodologies that can reduce impacts. So in this particular case, I think I've had in my testimony that we would plan to try to do much of the construction in summer and fall months. Typically, those can be drier. We can't exclusively perform construction during those periods, but we try to look at it with our contractors, identify the areas that are most vulnerable, and plan construction in those areas when we anticipate drier weather. We also try to incorporate feedback from landowners who know their property and communicate that to us either through open houses or more typically when we're discussing purchase of easements. They can provide us that feedback on particular sensitivities on their property.
Okay, thank you. That's all I had.
Okay. Are there any questions from Mr. Matthews for Mr. Morris? It's *6 to unmute yourself. You're appearing by phone.
Okay. Mr. Morris, can you hear me?
Yes, sir, I can.
I'm going to refer to your rebuttal testimony. To me, has a big C at the bottom. It has to do with a couple of questions. And it says, has XTI engaged in discussions with Mr. Matthews regarding alternatives or reroutes for the FDIM project? Do you recall what your answer was?
I have it here, yes.
Could you read that?
Yeah, on page 15 of my rebuttal testimony, starting on line 21. Yes, ATXI has engaged in discussions to obtain information from Mr. Matthews regarding his concerns and potential sensitivities or constraints on or near his property. However, as described above,
go ahead.
However, as described above, Mr. Matthews is proposing that the commission should order a wholesale change to follow a different route, such as DO 27.
Have you ever talked to me personally before today?
No, sir.
And who would have talked to me? Who would this individual be? Do you know their name?
I'm going off of recollection, but I believe Scott Gross. Typically, it would have been a member of one of our either our public outreach or a real estate professional.
Mm-hmm. Do you know what he proposed to me?
I do not recall at this time.
Yeah. He basically said he wanted to move the line maybe to the other side of the road, which would involve 70 acres crossing my property rather than 40 acres. Other than that, it was a very short conversation. So engaged in discussions to obtain information might be quite limited. On your first question is, has Mr. Matthews proposed route adjustments affecting his property? Can you read the answer?
Yes, beginning on line 17. No, Mr. Matthews does not directly propose any route modification in his direct testimony. Instead, Mr. Matthews appears to offer an opinion that Route DO-27 would be better.
Yeah. Well, if you go back to testimony I've given back in January and February of 2025, when I became really aware of this project, I did suggest and recommended that DO-27 be the one. I have a couple of other questions for you here. Can you describe what the corona discharge is for 345 volt power lines and what you do about it?
If you're referring to specific magnitudes or measurements, no. I'm generally aware of the corona phenomena.
Do you know the decibel level of that as a hum or a crackling? And when it's worse than at times?
I do not know the decibel levels. Again, I'm generally aware that in overcast or foggy days, it can be louder than on clear summer days.
Okay, thank you. Describe for me, because you were quoted in a rebuttal testimony by Mr. Nichols, what is a hog farm sensitivity?
Yeah, so
the hog. Yeah, go ahead.
The hog farm sensitivity, so we are aware of a property located along what was originally Route DO-27 that is owned by a USDA regulated entity which has hog farm operations.
Mm-hmm. How does it affect the reliability of the line and the cost? What my question is, because you state to ensure the reliability of the line and avoid unnecessary cost. What would those costs be, or what does that entail? Just explain it to me in your own terms. Trying to understand what sensitivities are to hog farms as opposed to a farm like mine.
Yes, sir. So generally, I would refer back to my rebuttal testimony on page 10 that outlines some of the restrictions that I'm aware of that exist on a hog farm. It is my understanding that there can be stringent requirements and restrictions associated with access to those properties to protect the health and welfare and of the livestock within the farm, and that those restrictions can be problematic for performing construction and maintenance on transmission or other infrastructure facilities.
And that wouldn't be true for anybody owning a house or planning on building a house associated with an easement, is that correct? It's only associated with hog farms?
I don't know that I could speak in absolute terms in the way that you have, but typically the easement languages that we agree upon with landowners do not contain the same type of restrictive access requirements that a USDA regulated facility would.
Yeah. And last question is, who owns these hog farms? Because they've been stated as the primary reason for why the switch was made.
Yeah, I'd have to look into our records for the specific owners, but I think it's Smithfield Farms. I think I've heard it referred to as KC2. I don't know. I'd have to look at the specific records though.
And would that be possibly an international company? It's owned by somebody else in a foreign country?
I think that may be correct, but again, I'd have to double check with our real estate folks.
Okay. Okay, that ends my questions. Thank you.
Thank you, Mr. Matthews. Mr. Harding, do you have any questions for this witness?
Yes, Your Honor. Good afternoon.
Good afternoon, Mr.
Morris.
Harding.
Just to follow up real quick with what Mr. Matthews said, do you know the hog farm property to be owned by the Chinese?
I do not.
Are you familiar enough with Harding Modification 4 to discuss it without review?
I'd have to probably look at the map to refresh myself on which one number 4 is.
If I could just refresh you, rather than identify it, I'll identify it this way. It's in data request 57.0, attachment 1, confidential. That lists the 4 Harding modifications. It's the one, if I may, it's what I consider the next era path. It follows the DO-27 route for quite a ways on the north part. Does that refresh your memory, Mr. Morris?
Again, at probably a general level, it probably depends on how specific the questions are going to be.
I just have one question about, here's my question, then we'll work backwards from that. Harding Modification 4 crosses 46 Highway in the same location as the DO-27 route did, but it is not the DO-27 route. It picks up the DO-28 in a different position, and what it does is avoids houses within this portion of the rerouted area on either side of 46 Highway, which is the highly populated area that ATXI has said from the start they were trying to avoid these residences. Those two options exist. Do you agree that either of those options, both of those options, do provide over 1,200 feet clearance to all residences in the proximity of 46 Highway?
So, again, I'd probably have to see the map to be able to answer it directly. My recollection is if it follows what was preliminary route DO-27 north of Highway 46, approximately 1,200 feet clearance to the nearest residences was an accurate statement.
I'd be happy to approach and let you see this if you want accuracy, if that's all right.
Yeah, that's fine.
Thank you.
So my question was about Harding modification as depicted there, and also DO-27, which I know you're familiar with, and I believe you already answered that. My question was, do both of those options at Highway 46 in that portion provide over 1,200 feet clearance to all residences along 46 Highway, and they don't impose on anybody else in the area depicted by Modification 4? The 2 points of Modification 4.
And again, I would say that generally sounds to be correct, and I'd have to confirm with Mr. Nicholas's routing testimony to confirm for those two specific residences.
And one question on the hog barn farm. Have you spoken to anyone that manages the hog barn farm? I know you listed some concerns, one of which was a lagoon. Are you familiar with any lagoons in the area that the line was going to go, old lagoons or new lagoons? Do you know of any of the concern that you listed in one of your testimonies?
I have not spoken to anybody at the hog farm directly.
And do you know of any such lagoons that you mentioned in your testimony?
No.
That's all I have. Thank you.
Okay. Cross from McGinley Farms.
Yes, thank you. I'm looking at 25C, which is your rebuttal testimony. Can you flip to that for me?
Yes, ma'am.
Thank you. Let's flip to page 14.
I'm there.
And for the sake of the record, we're going to avoid property owner names, but I'll note that there's a property owner named there. It's the owner of the parcel just to the west of Ms. McGinley. Are you familiar with that property owner, Mr. Morris?
Yes, ma'am.
Okay, and here, in lines 2 and 3, you said the representative of that parcel was unwilling to agree to any change from the proposed route. Do you see that?
I do.
That property owner did receive notice that their property would be impacted, correct?
I believe that is a correct statement, but I'd have to probably defer the specific answer to Ms. Detmers.
Okay, your original route depicted on this map impacts that property, correct?
They would be within our notice corridor for the proposed route.
Okay, so regardless of what her testimony says, this property owner should have received notice that they would be impacted, correct?
I believe that's a correct statement.
Okay, and so back to your statement that representative was unwilling to agree to any change. Is it fair to say that Ms. McGinley also doesn't agree with the proposed route over her property?
I think that is a fair statement.
If we flip to page 15, it's still your testimony today that the proposed McGinley modifications are, quote, technically constructible, is that right?
With the clarification that I believe the original modification 1 may impact a landowner that was not noticed.
Which landowner would that be?
We need to go into camera for this.
I think we can do it by directions, perhaps.
Yeah, I don't know the name of the landowner, so
Okay,
I
just
can't
making
even.
sure.
I believe southwest of the intersection there, so where the black line crosses the H. I'm not confident that that landowner has been notified.
Okay, so you believe the property that is essentially catty corner from the McGinley residence might be impacted?
I do not believe that they had been noticed in our original proposed route.
Okay, but so what you're saying is if we shift that black line to the northeast just slightly, that perhaps the lines could cross the McGinley property without the structures having to be in her row crop field. Would that be a possibility?
Pending engineering analysis, I would say that we had identified potential residents on the smaller property there. If you shift that black line to the northeast, you may impact that residence.
Okay, and are you aware about that residence is currently vacant?
I am aware of claims that residence is vacant. I have not confirmed anything.
Okay. Did you review Ms. McGinley's direct testimony?
At one point I did.
So do you remember seeing pictures of a house with no windows?
I remember seeing pictures of a house. I will take your word that there were no windows.
Okay, and also attached to her testimony was a for sale bulletin noting that there was investment agricultural land that made no reference to a residence. Do you remember that schedule?
I recall the for sale. I don't recall the specifics of it.
Okay. I want to talk a little bit, I think I was directed to you about costs. And so I think in your testimony, you suggested that the modifications would increase the cost. Do you recall that
I do.
generally? And I do believe it was actually, you were here for, let's see, I think was it Mr. Korsmeyer? I think it's going to add 150 feet and an angular structure. Is that your recollection of what the modifications would require?
That sounds proportionally correct.
Okay, and did you review staff's testimony in this case?
I did.
Okay, and so you are aware that Ms. Eubanks testified that staff wouldn't object to modifications that would be less than 2% of the total project cost. Do you remember her testimony about that?
I do.
Total project cost $120.5 million.
Correct.
And I am a lawyer, not a mathematician, but I'm looking at 2.41 million might be 2% of that.
Sounds right.
So staff says as long as it's under 2.41 million, they'd be okay with a modification, right?
Not necessarily speaking for staff, but that's roughly what I understand them to say.
Okay. And so we just talked about the and I don't think it's in the testimony what the exact estimate for the McGinley modifications are, but I think if we flip to page 12 of your testimony, you did put in an estimate for the Hyatt's modification, and there you would agree that you said adding, again, 1.2 miles and 6 heavy angle structures would be $1.7 million, right?
Medium and/or heavy angle structures, but yes.
Okay, so if we go from 1.2 miles to 150 feet and we go from 6 structures to 1 angular structure, you'd agree that the estimate for Ms. McGinley's modifications would be substantially less than the number for the Hyatts, right?
Yes.
Okay. No further questions.
Okay. Thank you, Ms. Bell. Are there any questions from the commission for this witness? Okay, hearing none. Redirect from ATXI.
Yes, Your Honor. Just a couple of questions real quick. Mr. Morris, do you know how many structures based off of the preliminary design were located on Miss McGinley's property, the parcel where her residence sits?
I don't know for sure. I believe there's at least one.
Is the line technically constructible with no structures to be located on Miss McGinley's property?
Along the proposed route, I don't believe it would be.
How about on any of the modifications 1 or 2?
I believe modification 1 would allow no structures on the property. Modification 2, I believe, would still require at least 1 structure on the property.
All right, no further questions. Thank you.
Thank you. Mr. Morris, I think you're excused. And now it's staff's witness.
Staff presents Mr. Sean Lange.
Okay. Mr. Lange, will you raise your right hand? Do you solemnly swear or affirm the testimony you're about to give is the truth?
I do.
Staff, you may proceed.
Please state and spell your name for the record.
My name is Sean Lange, ShawnLange.
How are you employed?
I am a senior professional engineer with the Missouri Public Service Commission staff.
Did you prepare a cause to be prepared, any testimony with regards to our recommendation marked as Exhibit 100?
I prepared part of staff's report, our recommendation, yes.
Do you have any changes or corrections to your part of that report?
Not to my knowledge, no.
And are the answers contained in your report true and correct to the best of your knowledge and belief?
Yes.
If I were to ask you the same questions today, would your answers be the same?
Yes.
I move for the admission of, well, actually, I'll just wait until we get to Claire for Exhibit 100. But I do tender Mr. Lange for cross-examination.
Okay. Thank you, Mr. Vandergrift. Cross by ATXI. Okay. Cross from Public Counsel.
Sorry. No cross, Your Honor.
Cross by Mr. Matthews. It is *6 to unmute yourself.
No cross.
Cross from Mr. Harding.
No, Your Honor.
And cross from Ms. McGinley.
No, Your Honor, thank you.
Mr. Lange, I think you may, are there any commission questions? All right, Mr. Lange, you can be excused.
Thank you.
Staff, your next witness.
Thank you, Judge. Staff now calls Claire Eubanks to the stand.
Mr. Eubanks, will you raise your right hand? Do you solemnly swear or affirm the testimony you're about to give is the truth? I do. Thank you. Staff, your witness.
Thank you, Judge. Good afternoon, Ms. Eubanks.
Good afternoon.
Please state and spell your name for the record.
Claire Eubanks, CLAIRE EUBANKS.
Thank you, Ms. Eubanks. And by whom are you employed and in what capacity?
I'm the manager of the Engineering Analysis Department for the Missouri Public Service Commission.
And are you the same Claire Eubanks who contributed to the staff recommendation in this matter, which has been pre-marked as Staff Exhibit 100P and 100C?
Yes.
And are you the same Claire Eubanks who caused to sponsor the corrected rebuttal testimony of Claire Eubanks, which have been pre-marked as Staff Exhibits 101P and 101C?
Yes.
At this time, do you have any corrections or additions to make to your contributions to Exhibit 100 or 101?
No.
And are your contributions to Exhibit 100 true and correct to the best of your belief and knowledge?
Yes.
And are your answers within Exhibit 101 true and correct to the best of your belief and knowledge?
Yes.
If I were to ask you about your contributions to Exhibit 100 or ask you the questions within Exhibit 101, would your answers today be the same or substantively similar?
Yes.
At this time, Judge, staff moves to enter Exhibits 100, public and confidential, and Exhibits 101, public and confidential, onto the record.
Are there any objections to Exhibit 100, public and confidential? So admitted. Are there any objections to Exhibit 101, public and confidential? Also admitted.
Thank you, Judge. And before I tender Ms. Eubanks for cross, we do have copies of her Schedule CME-S3, which is a comparison of the various route modifications, if the commissioners would like us to provide them a copy of that schedule.
I believe so, yes, thank you. And if at any time we need to go in camera for this portion as well, please let me know.
And if any party would like it as well, we can also provide that to the parties. But again, this is Schedule CME-S3 attached to the corrected rebuttal of Claire Eubanks.
And does staff intend to offer this as an exhibit or just?
It has been entered with her rebuttal. And with that, I tender Ms. Eubanks for cross-examination.
Okay. Any cross for May takes aye? Oh. Mr. Fosco, you're, yeah, thank you.
Good afternoon, Ms. Eubanks. Carmen Fosco for ATXI.
Okay.
And I'm sorry, just could you clarify, is your testimony about the cost limits for route modifications, is that confidential still?
I don't believe so. We had marked it confidential based on Mr. Morris's testimony being entirely confidential, and that was refiled, so that
Thank
was
you.
the correction.
Okay, thank you. I just wanted to clarify before I ask the questions in an open session. So you have a recommendation that any consideration by the Commission of route modifications should be subject to a cost cap of 1% to 2%, is that correct?
I think it's a more of a guideline, but to maintain some consideration of cost.
Okay, so the guideline would be that if a route modification or a combination of route modifications exceeds 1% to 2% of the project cost, you're recommending that the commission exercise caution before exceeding that
Yes.
level? And would you agree that that's sort of a macro limit on route modifications?
What do you mean by macro limit?
Well, let me ask it this way then. So that's an overall cost guideline, correct, based on the total project cost?
Yes.
And would you also agree that in approving any route modification, the commission should look at the specifics of the route modification, looking at a range of factors from feasibility, cost and benefits of the particular route modification?
I think that would be reasonable to do so.
Thank you. No further questions, Your Honor.
Thank you. Counsel, from the Office of Public Counsel.
Good afternoon, Claire.
Good afternoon.
Just quick questions based off of what Mr. Fosco said. So you were talking about you both were talking about your guidelines for the commission, and those guidelines, as he said, they are not hard and fast. If it would possibly cost slightly more, it's something that the commission should consider, but you wouldn't say don't do it if it costs 2.5% more.
So, one of the factors the commission typically considers is economic feasibility. So we wanted to give some guidance to the commission on where we would not be concerned that a modification could, it wouldn't trigger a new review from staff on economic feasibility of the project.
But they aren't hard and fast. They aren't, if it goes 2.1%, you wouldn't say we're going to have to re-look at all of this necessarily.
We will do what's asked of us of the commission, but I think it was supposed to be kind of a range.
Okay, thank you. That is all I had.
Thank you, Ms. Martin. Mr. Matthews, do you have any questions for Ms. Eubanks? It's *6 to unmute yourself if you're appearing by phone.
I do not have any questions for her.
Okay. Mr. Harding, do you have any questions for Ms. Eubanks?
Yes, Your Honor. Good afternoon. Good afternoon.
Good afternoon.
There's been a lot of... I think I can proceed in the interest of time, if that's all right with everybody. I'm just referring to the data requests. They started with 12.0 and went through 12.3. They all are aimed towards getting more information about ATXI's relationship with the hog barn property and who was notified. And so I don't know if you're the right person with staff, but I know staff did address and did make these 4 data requests.
I believe they're attached to my rebuttal testimony.
Okay, very good. Is it reasonable to assume that staff sees this property as eligible for a route, thus the request to find out whether anybody talked to them or not to get the concerns from firsthand people? Is
Objection
it
to the
reasonable?
extent it calls for a legal conclusion.
I'll restate.
I'll sustain it, but if you can restate it or rephrase it.
What is the reason that staff sent 4 data requests specifically about the hog barn property?
I think those were, to the best of my recollection, we sent those DRs after the local public hearing, and in part because of the issues raised by the landowners in this case, wanting to better understand what caused the reroute modification. I could be mistaken on the timing, but that's my recollection.
So it's your testament, no conclusion should be drawn as to whether or not staff's interest in that question should be considered, that property is eligible. Does staff have a position on whether or not the hog barn property is eligible?
Are you asking if the hog farm was notified of the?
No, I'm asking if notifications are kind of a separate subject at this point, I think. But does staff have a position as to the eligibility? DO 27 was going to go on the hog barn property for approximately half a mile.
That is my understanding.
Yeah, and it's a point of, it's the biggest point that ATXI is relying on, that they will not consider DO 27 the alternate route as determined by staff. And I'm just wondering if staff has a position on whether or not the commission should consider the hog barn property as eligible, or do you consider it ineligible, not to be considered? Those data requests are 12.0, 12.1, 12.2, and 12.3 for reference, but they basically just deal with It's a request to find out if there was any communication between the company and ATXI, which we have reconfirmed that there was no communication.
I don't think staff has a particular position on the hog farm property itself. We
As far
wanted
as-
to provide information for the commission so they had the information to make a decision.
So staff doesn't have a position on the eligibility for a line to go on there, or it's not, you don't have a position on the eligibility of it?
I guess I'm struggling with that. I don't know what you mean by eligibility.
Staff argues that the concerns for contamination, that it's to be avoided because it's somehow a USDA hog farm facility.
I think that is ATXI,
That's an ATXI position, correct?
right? That is not staff's position.
Okay, staff, okay, very good. Then I want to ask you one other thing. Commission ordered, and I believe it was the staff's recommendation, the LPH, January 16th LPH, and you're familiar with that?
I am, yes.
Does staff consider, I know the reason for that, as I read, is it staff's position that that January 16th LPH satisfied notice to the people along DO 27, even though they weren't sent the July 5 letter from ATXI?
Objection to the extent it calls for legal conclusion.
Sustain. Can you rephrase your question?
Yeah, I apologize, I'm not sure what the objection is. What was the purpose of the January 16th LPH from staff's point of view?
From staff's point of view, we received comments and we heard local public hearing testimony about landowner concerns between the reroute of DO 27 to DO 28. We were aware through data request responses that landowners on DO 27 didn't receive notification of the CCN application, though they were in the study area, as I understand it, for the open houses. So that was part of staff's recommended conditions in their recommended report. And that was the purpose of having a second local public hearing, to give the opportunity to landowners to express their opinions on that reroute.
Would staff consider there to be any reason to notify those people other than that they are being considered? Why else would they need to be notified?
I think it's similar to, let me take a step back. The commission rule requires notification of the CCN application. And for a landowner to know what an impact is on their property, they need to have an idea of where the route is proposed to be on their property. So to the extent that landowners on DO 27 have proceeded along the past year or so with the understanding that DO 28 was the proposed route, which is what is in the CCN application as a Appendix E of ATXI's application. I think that's, I guess I struggle if I was in that position, how I would feel. And I think that's,
What would be the point of providing them an opportunity to speak to their property if their property wasn't being considered for a route?
in the local public hearing.
Yes.
I think there was discussions in the, if I'm recalling correctly, in the original local public hearing, there was a lot of discussion of DO 27 and DO 28.
And so it was to satisfy it was to provide the opportunity for the people along the DO 27 route to provide input, correct?
Yes.
And the reason that you would entertain that opportunity or provide that opportunity for them to provide input would be because their property is being considered for this project. Is that a correct assumption? And I'm trying to figure out what other reason you might notify those people and give them opportunity with an LPH if they had no reason to need to have an LPH.
So it could also provide useful information to the commission on whether there were concerns with DO 27 that maybe were not raised otherwise.
So is it more of a checkbox to have provided that just to meet the requirements of the regulation?
No, I don't believe it was proposed to, as a checkbox, no.
So is it your testimony that the LPH in January 16th was to provide landowner input so that the commission could further assess DO 28?
I think it was, the intention of it, whether it was helpful or not, was to provide the commission an opportunity to hear from landowners on both DO 27 and DO 28 to the extent that it is an option that's not really, I think that's what you're getting at, is DO 27 an option of the commission?
Staff has stated that it's an alternate route. Staff stated that they consider it an alternate route. Is it an alternate route that is not eligible? I don't understand.
I don't understand.
Objection to vague.
Can you clarify your question, Mr. Harding?
Does staff consider DO 27 an alternate route in this case?
I believe in the staff report is what you're referring to. We were concerned about DO 27 and whether or not it was a known alternative route. So not saying that it is or it isn't, it just was not, it was not clear.
And so, did staff recommend the commission order an LPH on January 16th?
Objection asked and answered.
Sustain.
Was there an LPH on January 16th?
Objection asked and answered.
Sustain.
Can you provide me why there would be an LPH for the purposes of allowing people along a DO 27 route only to help the company reroute DO 28 better? Why would you have an LPH that's specifically for DO 27 people that doesn't pertain to that route?
Objection asked and answered.
Sustain. Do you have any more questions for the witness, Mr. Harding?
No.
Okay. Thank you. And from McGinley Farms, is this going to be lengthy? I wanted to take a brief recess if so.
One question, Your Honor.
Okay.
All right. You passed out the chart that's attached, I believe, to your corrected SIR rebuttal. And if we're looking at that chart with respect to the McGinley modifications, you had indicated for modification 1 that it did potentially affect non-notice landowners. Do you see that? I do. That wasn't an independent review undertaken by you. That was completely based on Mr. Morris's testimony, was it not? That's correct. Okay, and you heard him talk with me about that piece of testimony today, correct? I did. Okay, that's all.
Are there any commission questions for this witness? Okay. Chair Hahn has some questions.
Good afternoon, Ms. Eubanks.
Good afternoon.
As part of the staff conditions or recommendations in this case, I think we've recapped that staff recommends the totality of any modifications to be anywhere from 1% to 2% of the total aggregate project costs. Mildly concerned that may pit certain landowners' upgrades or modifications against others, looking at the total costs. If we were to take into account all of the landowners' modifications, I think it may exceed 2%. Would that also be your understanding?
I am not sure because if you're looking at the schedule, the Hyatt modification, I think we learned today that they're not part of the proceeding today. And some of them, I don't have a specific dollar amount for. And some of them, presumably, I will say, if I'm understanding correctly, Harding modifications 1 through 4, maybe not all of them were specifically recommended by Mr. Harding. But presumably if one of them were to be ordered, and then, yeah, I'm sorry, I just can't answer that question. I don't know for sure.
Okay. That's all the questions I have.
Are there any other commission questions? And I kind of have a piggyback of that. Are there any modifications that would fall within the factor, ceiling is the word I'll use, that staff provided in CME S3?
You're specifically asking about the cost impact.
Really all three factors, but especially the cost impact, yes.
So most of the modifications impact a landowner that did not receive notice of the CCN application. We do note that McGinley modification 2 appears no, that does not. And then DO 27, there was the notice of the local public hearing. Both have an increase, but I don't know the specific dollar amount. And DO 27, since that was something that ATXI had studied, it was where it was feasible, routed along roads, corridors, or property lines. The McGinley modification 2 is not.
And as kind of a follow-up to that, on line 3, of page 3, on line 2 to 3, really 1 to 3, you state that the intervention deadline, that modifications have directly affected landowners who were not notified prior to the intervention deadline in April of this year should not be considered by the commission.
That is my recommendation, yes.
Okay. I don't have any further questions. Are there any other questions from the commission? Okay. Do we want to take a brief recess, or do we want to
Your
go
Honor?
through recross? Sorry.
I didn't know if this is Mr. Harding.
Yes.
I didn't know if I was going to get a chance to respond to some things that Ms. Hahn said and you said.
You would in recross. Do we want to take a brief recess first before going to that? Why don't we?
I would ask Ms. Eubanks if she would like to finish up or if she's okay with a recess.
I'm fine either way, whatever the commission prefers.
I only have one question. It will be brief.
Okay, we'll go ahead and do the recross here.
In response
Hold
to
on,
it-
Mr. Harding. There's an order. Sorry. It'll begin with ATXI. Is there any recross from ATXI? No recross. Okay, and then the Office of Public Counsel?
Just one question. When we're looking at this sheet, this is for each individual modification offered, correct? So there are 2 McGinley modifications, there are 4 Harding modifications.
So I was basing the numbering and naming convention off of Mr. Morris's testimony.
Okay, but it is, the increase that you have on one. It wouldn't be, it's not just, sorry. Let me give a better, more solid example. So Harding Modification 2 and Harding Modification 3, the 800,000 for Harding Modification 2, the commission could do Harding Modification 2, and that wouldn't necessarily be actually 1,600,000. Is that right?
If the commission ordered Harding Modification 2, it would be 800,000. Yes, and then the depiction of what Harding Modification 2 looks like is on the maps that are attached, which I don't know that those were handed out, unfortunately, but they are in EFIS.
Okay. Okay, so, but if you were, let's use McGinley, and the commission took McGinley Modification 1, but not McGinley Modification 2, that increase that you consider is just the increase that you put for McGinley Modification 1, correct?
Unfortunately, I was not provided a cost estimate for either McGinley modification. Okay. And that's why I couldn't really answer Chair Hahn's question earlier.
Okay, but they're not interconnected, is?
They are not interconnected to my knowledge, no.
Okay, thank you so much.
Okay. Now, Mr. Matthews, do you have any recross of Ms. Eubanks? Any questions based on the questions that Chair Hahn and that I asked?
None.
None? Okay.
None.
Okay, and Mr. Harding?
Yes, I believe there was a discussion about Harding modifications 1 through 4. And do you have any knowledge of Harding modification 5, which was recently displayed on the interactive map on Ameren for about 10 days? Do you know about that modification?
I don't know what you're referring to without looking at it.
Okay. Are you aware of any display of any modification that's been displayed on the Ameren interactive website between October the 10th and the 20th?
Of this year?
Yes.
I've not been to their website during that time frame of 2025.
Yes, 2025, just recently.
Just recently,
a few days ago.
I don't recall looking at the website in the past couple
And
weeks.
you have no familiarity with Harding modification 5?
If it is not on, no, I don't believe so, no.
Okay, thank you.
Okay. From McGinley Farms.
Sure, just briefly, Your Honor. If we're looking at the McGinley modification, they did, ATXI did testify the additional feet and structures that would be required. So if we compare that to the Hyatt modification, which is now, as you testified, off the table, correct? Or not part of this case? That's my understanding. Okay. And so they had estimated a price for 1.2 miles and 6 structures for the Hyatt's recommendation, correct? That is my recollection, yes. Okay, and I think that was $1.7 million? Yes. Okay, and you'd agree that one structure is 1/6 of the 6 structures for the Hyatts? I don't know if they're the same type of structures. Okay. But I think you did talk to Mr. Morris earlier today about the cost impact being less than the 1.7 million. Sure, and the 150 feet required for the McGinley modification would be 2% of the 1.2 miles required for the Hyatt modification, so significantly less. Yes. Okay, thank you.
Any further questions?
No, Your Honor, thank you.
And redirect.
No redirect, Judge. Just ask that Ms. Eubanks be excused.
Ms. Eubanks, you may be excused. Would we like to proceed with, I believe it's Mr. Matthews. Want to go ahead and go through? Okay. Mr. Matthews, are you there?
I am.
Can you please raise your right hand? Just let me know when it's raised.
I have.
Do you solemnly swear
I
or
have.
affirm Do you solemnly swear or affirm that the testimony you are about to give is the truth?
I do.
All right. Mr. Harding, do you have any questions for Mr. Matthews?
No, Your Honor.
Okay. McGinley Farms, do you have any questions for Mr. Matthews?
No, Your Honor.
OPC, Office of Public Counsel.
No questions, thank you.
Okay. Staff,
No questions, Your Honor.
ATXI. Do the commissioners have any questions for Mr. Matthews? Okay. Hearing none. Mr. Matthews, you're no longer under oath. Well,
Okay.
you're released. to
Thank you.
listen.
Your Honor,
Sorry.
I'm not sure, did you admit his testimony into the record?
I did not, sorry. I don't know if there's an exhibit number for that testimony. I honestly don't know where it would fall.
I believe there were some numbers in one of the orders.
Procedural
Yeah.
schedules, right. Okay, I can try to find that real quick. Order setting procedural schedule, should be that one, right, in July?
That sounds right. Should have been the first one, yeah.
Okay. Mr. Matthews, that would be 851 should be your testimony. And you had rebuttal. Was it just the 2 injuries? Is anyone aware?
Yes, and then there was a statement of position.
Okay, yeah, that's separate. Are there any?
I see, okay.
And were either of those confidential? Do we know? I know that ultimately we had things revised and filed again.
I think I opened them up. I think I rechecked the box or unchecked it, or we refiled them.
Okay. I don't know that any of them are still confidential.
Correct.
Just checking real quick. That's okay. And then there was an amendment. Okay. Yeah, it looks like they're both public. Are there any
Okay.
objections to 851 or 852 being admitted? Okay. Hearing none. Those are so admitted. And now, Mr. Matthews, if you'd mute yourself, we can proceed. Okay. Mr. Harding, can you come to the stand up here? You please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give is the truth?
I do.
All right. Beginning with Mr. Matthews, do you have any questions for Mr. Harding? It's *6 to unmute yourself if you're appearing by phone. Can you hear us, Mr. Matthews?
Yes, I can. Yes, I can.
Do you have any questions for Mr. Harding?
I do not.
Okay. Thank you. From McGinley Farms, any questions for Mr. Harding?
No, Your Honor, thank you.
Okay. From the Office of Public Counsel?
One moment. I just want to make sure. I turned it back off, didn't I? I cannot find the document that I was going to ask about, so for right now, unless I find it, I will let you know. But I have no further questions, or I have no questions.
Okay. From staff, are there any questions?
No questions, Your Honor.
From ATXI?
Your Honor, we have no questions, but we do have some objections.
Okay. Is this to the exhibits?
Yes, Your Honor. Mr. Harding's testimony does at least two things. One is he purports to present the position of his family member, and he's not an attorney in this proceeding. And then secondly, there is much hearsay testimony about third parties. What we would ask as our objection, Your Honor, is that you acknowledge our objection by recognizing that we can freely argue that that testimony should not be given, or that we can make arguments as to weight of that testimony.
I think that's fair. Okay. Otherwise, I believe there's direct and surrebuttal testimony, I think is all for Mr. Harding. Additional. I don't see the surrebuttal on your, oh, no, there it is. Okay, so is it 806, public and confidential? Any other objections, other than the standing objection from ATXI? Okay, and then 811 is the surrebuttal. Any other objections to that as well? Okay, so admitted. Are there any commission questions for Mr. Harding? Okay, Mr. Harding, you may be excused. Thank you. And next is McGinley Farms. Let me call your witness.
We call Judge Rebecca McGinley. Yeah, I would just take that testimony. Here, this one too.
Okay. Ms. McGinley, may you raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give is the truth?
I do.
Thank you. You may inquire of your witness.
Please state and spell your name for the record.
Rebecca McGinley, McGinley.
And how are you currently employed?
I'm an associate circuit judge in Gentry County, Missouri.
And state your position as it relates to this case.
I'm a landowner.
Are you the same Rebecca McGinley that caused to be filed direct testimony in this case, which I've marked Exhibit 950, and public and confidential versions of surrebuttal testimony, which I have marked Exhibit 951P and 951C?
Yes.
And I believe you have one correction to your direct testimony, is that correct?
Correct.
Can you flip to Schedule MS7?
I'm sorry, are you in 950?
I am. Actually, let me check here. No, I am in the confidential version, so I'm in 951C, I believe.
I'm sorry, MS7?
Yes.
Yes.
All right, and what correction do you have to that schedule?
I think we put the stole parcel on my property instead of putting it below.
Right, and so the map packet I handed out earlier has an arrow that just points to the actual stole parcel. I'll refile that corrected exhibit in EVIS.
Okay.
Is that okay, Your Honor?
Are there any objections to filing that? Okay. No.
All right, and if I were to ask you the same questions in your direct answer rebuttal testimony today, would your answers be the same or substantially the same?
Yes.
Your Honor, at this time, I'd move for the admission of 950, 951P, and 951C with the corrected exhibit to 951C.
Are there any objections to Exhibit 950 being entered? Or 951, public and confidential? So admitted.
And I will tender the witness for cross. Thank you.
Okay. Beginning with Mr. Matthews, do you have any cross for Ms. McGinley? Is star 6?
I do.
Okay.
I do. Explain or how does the CRP property affect the transmission lines that cross it? And what are the rules and regulations that you've come up against with regards to that property that's under CRP and a contract?
I actually have not explored, I have not talked to the FSA office in regards to what problems I might have. I let my attorney know, which is in my testimony, that my contract goes until 2035. I don't know what effects it may have, and I think that was one of the concerns that we raised in my testimony, is I don't know what it could cause in regards to that contract.
Thank you. I asked that question because I'm faced with the same thing. And of course, these days with the USDA closed, I get nothing but crickets for an answer. So that's an important consideration because we sign contracts and I don't want to have to pay back the last 15 years of them because of an easement or transmission line and towers. So thank you for addressing that. It needs to be looked into by somebody.
On behalf of the company, Judge, I would ask that that statement be stricken from the record.
Sustained. Mr. Matthews, when you're questioning a witness, you cannot testify. You must ask questions.
Okay. Okay.
Do you have any further
That's all I
questions?
had.
Okay.
No.
Thank you. Mr. Harding, do you have any questions for Ms. McGinley?
Yes, if I may. Hello, Ms. McGinley. Do you know the linear feet from the line as is proposed to your house currently?
It's about 400 feet.
And do you know the linear distance in feet to each modification that you're advocating for?
I'm advocating for at least 1,000 feet.
Thank you.
Any further questions, Mr. Harding?
No, that's all, Your Honor.
Okay. The Office of Public Counsel.
Just a couple. So, in your testimony, you focused on the lowering of property value due to the transmission line. Have you discussed with the company any sort of mitigation for specifically your property's home value and any decrease in that property value that you may face?
We've raised that, but my main concern is just getting it farther away from my home place.
Okay. And have they talked to you about any sort of mitigation for safety? Anything about?
No.
Okay, thank you.
You're welcome.
Are there any further questions? Okay. Questions from staff?
Staff has no questions for Judge McGinley, Your Honor.
And ATXI? No questions, sir. Thank you. Are there any questions from the commission? Okay. You may be excused, I guess redirect. Are there any redirect questions?
No,
Sorry.
Your Honor, thank you.
Okay. You may be excused. I think now we can go through exhibits. If there are any other matters before the commission? Is there anything else to address with the commissioners present? Okay. Yeah. The commission can be excused. We can go ahead and address the exhibit list. Just trying to keep pretty good track. I have one through 7C were admitted. Then 818, I also have admitted. 813, 830, and 833 were all admitted. 803 was not admitted, correct?
Yeah, I believe 803, that was a page from Exhibit 100.
Right, okay. And then 826, it was admitted, but an unaltered version to be filed. Correct? Okay. 812 and 813, under that same purview of unaltered. Okay, 829 was not admitted.
Correct.
Okay. 823 was admitted partially, I guess the best way to put it. Page 203, the maps on the next page, and then page 303, 3 of 3.
2 and 3 of 3. Yes, you're,
And then there was a map page in between, I think, that was also admitted. I don't think there was objection to that. Okay. For 820 public, the first several pages until 506, 5 of 6, sorry. Okay. And that was the same for 820C. 800 was admitted. I'll try to get through this. Then 8, 9, 10, 11, public and confidential were all admitted. 837 was not admitted. Then 840 confidential was admitted. 828 was admitted unaltered. 801 and 841 confidential were withdrawn. The same for 811 confidential. So those were not offered. 825 confidential was admitted unaltered, so to be filed. 952C was admitted. Then 12, 13, 14, 15 public and confidential were admitted. 16, 17, 18, 19, 20 public and confidential were admitted. 21, 22 public and confidential were admitted. Then 23 public and confidential, 24, 25 public and confidential. Correct? Have I missed
Correct, Your
anything?
Honor.
Okay.
No.
Then moving to staff's exhibits, it was 100 public and 100 confidential and 101 public and confidential.
That's correct, Judge.
Okay, and those were all admitted. 851 and 852 were admitted. Then 806 public and confidential were both admitted. And 811 public and confidential were admitted with over objection. Then 950, 951 public and confidential were admitted. Is there anything I missed?
I'm sorry, did you say 952?
I
Was the
believe that was
DR.
earlier.
Okay, perfect.
I have a list when they were, yeah, I have it
Thank you.
earlier.
And I do apologize.
Yep.
Would it be okay, because I know that there were some, because I was trying to follow along as things were going on. Can I make sure that we have no customer facing or customer information in the unredacted things too? Because I don't want to accidentally do that.
Sure. Are we aware of what has confidential information?
I know that there were some that I didn't realize until later, so I just
Sure.
wanted to.
I want to say, I can go through, try to be quick about the ones that I marked C on, and where there's a C and a P. Most of these fall in Mr. Harding's exhibits, correct?
I think so.
And I thought in Mr. Harding, he seemed like most of the confidential exhibits, you did have a confidential in the corner of most of those that should be marked confidential, correct?
How about before I enter everything, if people can review it and let me know if there's anything that needs to be marked additionally, based on the list I gave, if anyone has any corrections to it, and have that filed by the end of the week. Okay. Is there any other issues to be brought before today? I think there were, again, some late filed will be late filed exhibits due to corrections to the unaltered, to have unaltered versions. Do we want a deadline on that, or what deadline do we want? I think it's November 18th, correct, is when the briefs are due, and transcripts are due on the 10th, I believe. So, do we want to say till the 4th or 5th to have those filed, or even just this Friday, since they should be easy to find. The 31st? Are there any objections to the 31st as a deadline to file any late filed exhibits?
No objection from the company.
Okay. So 10/31. And any objections to those exhibits should be filed by, I'll say the 5th. Just make it easy. So 11/5. I think, again, I mentioned the transcripts by the 10th. Is there anything else that needs to be discussed today?
So, Your Honor, Carmen Fosco for the company,
Yes.
a question. We had exhibits 26 through 44 in our exhibit list, which was the pre-filed testimony of the witnesses with issues addressing uncontested issues that were not at issue at today's hearing. I'm not certain if Your Honor is going to admit that testimony for all parties, or if I should separately move to admit that now.
I can admit those if there's no objection. Okay, those will be admitted as well.
And I believe, the attorneys for MEC are still on. They can speak up as well, but they also had pieces of rebuttal testimony that, per our procedural schedule filing and the order approving that schedule, those four or five pieces of rebuttal testimony would also be entered on the record.
Judge Fuel, this is Peggy Whipple. I'm still on for MEC. Mr. Pringle is correct. MEC's exhibits are numbered 300 through 309. Only 302 is a C version for which there's no public version. This list was filed on September 9, and if there are no objections, if it is necessary, I would move for those to be admitted into the record, please.
Okay. Any objections to those exhibits? Okay, so admitted.
And Your Honor, just for a clarification on the company
Yes.
exhibits, of exhibits 20, of those exhibits that I mentioned, 42 and 43 have confidential and public versions.
Okay, thank you. Yes.
And then, Your Honor, we have a disc with our hearing and exhibits on it. Should we tender that to you at the end of the hearing today?
Yes, I'd appreciate that.
Okay. Thank you.
Thank you. Okay, if we have nothing further to discuss, then we are adjourned. Thank you, everyone.